Good evening, Namaskar and welcome. Dear students, we, on behalf of the Board of Studies, the Institute of Chartered Accountants of India, myself, Nisha,
and C.A. Shraddha,
welcome to you. In today's session, we shall be discussing about the chapter 1 of your part first of the syllabus, that is the corporate law covering the Companies Act 2013. In fact, from today, we are starting the technical sessions, in fact. So this chapter has a great relevance because it contains the definition clause, the extent and commencement and application of the Act. But this will definitely let you know what is the background for the enactment to come into enforcement and what were the reasons that made this Companies Act to be replacing the old legislation of 1956 with the new legislation, the Companies Act 2013. In fact, in chapter 1, which is named as the preliminary, in this chapter, we shall be discussing about the title, extent, commencement and operation of the Act, how does the Act came into enforcement, and further with that, we shall be discussing about the relevant and important definitions that is being covered under the section 2 of the Companies Act 2013. If you define what we are actually covering in this chapter is just the section 1 and 2 of the Companies Act 2013. In fact, today we are intending that out of this session, you will be at least learning and understanding at least 5 of the important definitions that will help you while preparing for your examination. And also, it will help you recalling the sections at the time when you are preparing for your examination. At that time, you will not only easily and able to understand particular provision during that time, but also it will save your time in learning. And already said, because save in time saves the time. तो मीन्स आपको समय की बचत करनी है और समय का बेस्ट यूटिलाइजेशन करना है. तो इसके साथ ही हम अपना टेक्निकल सेशन स्टार्ट करते हैं. लेकिन इससे पहले कि हम आपको कंपनीज एक्ट सेक्शन 1 एंड 2 यानी प्रिलिमिनरी चैप्टर्स का मेन जो चैप्टर का पार्ट है वो स्टार्ट करें, बिफोर दैट आई वुड लाइक टू जस्ट through an insight on the development of the Companies Act 2013 that has come into the present form. But yes, before that, we would like to greet to every student, Nitin Kumar Mahanta, Hitesh Jain, Jinesh, Nipun Gupta, Parampreet Kaur, Anikesh Srivastav, Jayendra Kumar, Pareen Pratima, Shivam Dhuria, and the Meena Kumari. A very good evening to all. And we are really very much excited and we are very pleased to see you back here, and we are really very much, you can say, pleasure to connect to you once again through this platform.
And Janisha, as you have said that the voice is low, hope you are able to hear the voice clearly now. If there is still an issue, please drop a message.
Yes. So as I said, let's know how the present act came into enforcement. Yes, the first Indian Companies Act, which was enacted, was the Indian Companies Act 1866. Which was recast again in 1882 as the Indian Companies Act 1882. This act was actually based on the British Act. Because as you all know, when the Britishers came to our India, they have just brought the business and the transaction and the commerce by regulating and adopting their own laws in India. And that is why most of the laws are based on the British Act. And after that, the Indian Companies Act 1882, it was repealed and it was replaced by the Companies Act 1930. And after that, it was replaced by the Companies Act 1956. And that act has been continued for 57 years. That is more than half century. But then what happened? All of a sudden, that act has been repealed and replaced.
The changing dynamics of the economy and the behavior of the people, and with the international transactions that are taking place. And if you see, we have been dealing with cross-border merger.
In tune with the national and international economic environmental scenarios to accelerate the growth and expansion of our economy. This Companies Act 2013 was enacted. And in fact, it came into enforcement on 30th of August 2013 through the publication in the official gazette. And due to introduction of many new concepts and due to tremendous change in the Companies Act, in the, you can say, in the economic environment, this led to the enforcement of this Companies Act 2013.
And it replaced the Companies Act 1956.
And also, besides that, there were many acts that were influencing the provisions of the Companies Act.
Yes.
Such act like SEBI, you all must be knowing about the Security Exchange Management Act. Then, if you see, there was a FEMA. Yeah, Securities Contract Regulation Act.
SCRA is there.
Yes, and
Depositories Act is there.
And the Insolvency and Bankruptcy Code. These are all the important provisions which are also influencing on the Companies Act 2013. And that is why they just focus to replace, to reduce the effect of, to cover more of the scope of this corporate requirement. They come up with new enactment, and that was the Companies Act 2013. So this was the basic background, and you should know that why these companies have been enacted in different phases, why it has not come the entire act enforced in one go, you can say. So you must be saying that the Companies Act 2013, which was enforced on, as I said, on 30th August, on that day, only Section 1 was made applicable. That means they said the Companies Act is being enforced. Okay, the Section 1, which specifies the title, extent, and commencement, and the application of the act. Only this section was made applicable, where rest of the sections, they said to make it applicable on different dates. And they said that different provisions will be made applicable on different dates through different notifications. Yes. So this was the thing. Why this has been done? Because due to adoption of many changes and the introduction of new concept, as already we have said, this takes a time, and they just wanted to say there may be not a problem in the execution or implementation of the law. And that is why they enacted in a phase-wise manner, so that wherever required, they can accordingly modify and make changes to make it go easily and conveniently. So this was just the basic background. And let's talk about now the Companies Act 2013.
Dear students, good evening once again, and thank you for your wishes. This voice issue is that there is a time lag between the video and the voice. It will be solved in few minutes. Actually, when the video starts, there is generally a bit of a time lag. After some time, it becomes normal. So I think it should be in a position to resolve in a few minutes. Thank you for your feedback.
Yes. Further continuing with the introduction of the Companies Act 2013. Now, if you see any of the act, any of the barrack, you must be seeing that after the name of the act, the title of that, you are seeing a certain few lines are written there. What is that? I hope you all must have seen the barrack. And if you have not, kindly go through the barrack and you will be seeing a certain lines are written. That is, what is that? That is the preamble of the act. Why the preamble is given after the name of the title of that? Why it is so necessary? If you remember, in my last session also, I have told you, during the first reading of the bill, there is an introductory, you can say, reading, introductory stage actually, you can say. There, what happens, you just give the introduction, why the act has been written, what is the object behind the introduction of that act in the parliament, that bill particularly in the parliament. So this is because the preamble lays down the objective, the scope, and in fact the purpose of the act. So this is very much required, because when you are knowing that what is the intent of the lawmakers behind such an enactment, it gives you a clear picture with what intent the law has enacted and who all are going to be benefited out of that act, whose interest will be safeguarded. So in that case, the preamble generally recites the ground and the cause of making a statute of the statute, as well as they also look after that what are the defects or the mischief or the flaws which are lying in the act and how they can be remedied.
So in short, if I can say, ma'am, preamble gives the why of the bill, or which will in future become the act. So in one word, we can say it gives क्यों हमने ये काम क्यों किया. It gives us the why of the act.
बिल्कुल. और दूसरी चीज में ये होता है कि जो preamble होता है, आप उसको ये मत समझिए कि it will override the plain provision of the act. जी नहीं, वो हम तब इस्तेमाल करते हैं when there is any contradictory or where there is, you can say, doubt arises with respect to what intent any particular word or phrase is used in the act. The at that time, we refer to the intent of the law. With what intent that law has been framed and what meaning or what you can say interpretation that we can draw over there in case of the contradictory of that word, or what that words really intend there with respect to that particular law. So there in that case, we see the preamble. And in fact, preamble they are going to learn in our other law portions also. You'll be seeing this is the chapter 4 under the part 2nd of your syllabus, that is the other law. And this is also one of the important topics because this really helps in the interpretation and construing of the laws.
So during today's session, sometimes we will be using such terms and we will be explaining them to you also, though they are not covered in the chapter as you see in the study material of the institute. However, they are forming part of the chapter 4, which is interpretation of statutes, of part 2 of module 2. But since they will be helping you, and you should know how to read a particular line, or rather you should know how to read the act. So we will be dealing simultaneously or in between the definitions of that also, to a little extent on.
Even law is interconnected in many of the, you can see interconnection is there between one law and the other. So it's important when you are reading a single law, you should read in conjunction with the other laws in order to understand the real, what the law is and how it can be interpreted in different contexts, and it is seen best in the light of the act, which is with its particular it prevails.
However, from the examination point of view, when you are being asked a question, it is requested that try to stick to the answers which will be based on the Companies Act 2013. For knowledge purpose, definitely you should link it with other acts also.
बिल्कुल हमारा उद्देश्य सिर्फ इतना ही नहीं है कि हम आपको सिर्फ इंटरमीडिएट लेवल के हिसाब से एग्जामिनेशन के हिसाब से पास करने के हिसाब से आपको उतना ही इंफॉर्मेशन दे, उतना ही पढ़ाएं. हम इनफैक्ट ये चाहते हैं कि जब भी आप बाहर निकले इस कोर्स से पास होके जब आप सीए बन जाए तो आप ये कहे कि यस आई नो व्हाट द अदर्स आर नॉट अवेयर ऑफ, सो दिस इज अ सीक्रेट, यू डू समथिंग डिफरेंट व्हाट अदर्स वोंट डू. तो ये चीज आप ध्यान रखिएगा, जो लोगों को नहीं पता है वो आपको पता है. दिस इज ऑल्सो वन ऑफ द सीक्रेट ऑफ द टुवर्ड्स द सक्सेस. Yes, I was talking about the preamble part. I told you if you see the act, तो act का preamble दिया हुआ है that Companies Act 2000 is an act to consolidate and amend the law relating to companies. अरे इतने भारी भरकम शब्द consolidate, amend the law relating to the companies, क्या समझ में आया होगा बच्चों को? श्रद्धा,
मुझे नहीं समझ में आया. Even I am not able to understand.
जब आप consolidate की बात करते हैं तो yes, you are combining many of the things, many of the issues and make the law strong. क्योंकि जो पहले जो भी लॉज हमारे थे प्रीवियस लॉज, उनमें कुछ कुछ कमियां थी और उन्हीं कमियों को दूर करने के लिए एवरी टाइम वी रिवाइज टू बी ट्यून विद द चेंजिंग सिनेरियोज. अब इन्होंने क्या किया कि हम अपने लॉ को स्ट्रॉन्ग करेंगे, एंड दैट इज व्हाई जब कंपनीज एक्ट 2013 आया तो उन्होंने प्रेम्बल में क्लियरली स्पेसिफाई किया टू कंसोलिडेट मीन्स टू मेक our law more stronger by combining all this aspect which has been missing over there, and to amend the law. आपको लॉ तो बदलना ही, उसमें अमेंडमेंट करनी है, आपको नई नई चीजें डालनी है, तो आपने उसको अमेंड किया रिलेटिंग टू द कंपनीज. So this is what the preamble of the Companies Act 2013.
One more thing, students, whenever we are using Hindi words, we will be using English also for the same. Since I told you in the last class also that we have a pan-India approach, so we will be using English also for the same things which we are discussing, which we may discuss in Hindi.
Yes. Then after that, we'll talk about the enactment of the statute. So I will say the Companies Act 2013. It received the assent of the President on 29th of August 2013. Okay, please note down. Received the assent. Yes.
Of the President.
Yes.
On 29th of August 2013.
And it was notified in the official gazette on 30th of August 2013 for public information.
So students who must have attended the last class would be knowing that from which state it is applicable and why.
And you also must be knowing when a bill is set to be becoming an act. These are all the steps actually. When it receives the assent of the President and when it is being notified in the official gazette, that bills become the act. So here the act came into as I said, it came into enforcement from the date of the publication of the official gadget, that is 30th of August 2013. And it also specified that the entire act is not going to come into the enforcement. So it clearly mentioned in there that the different dates may be appointed for the enforcement of different provisions through different notifications. They made it clear. So that is why, if you remember, when the Companies Act 2013 was notified on 30th this August, at that time only Section 1.
You don't have to remember it. It's
just for your information. Yes. Section 1 came into enforcement at the very moment from the date of notification in the gadget. And whereas for the rest of the remaining sections, if you remember, they have made in a phase-wise manner. If you remember, initially, first time the 98 sections were made applicable in September 2013, and later around 143 sections were made applicable from 1st of April 2014. So this is how they have not made the entire act to come as at once, but in a phase-wise manner. Then later on, if you see what are being covered under this act. So the Companies Act 2013 is basically, you will see there are 470 sections divided among 29 chapters with 7 schedules. And also, since it's a rule-based legislation, so rules, along with this, rules also forms the part of the Companies Act 2013. And if you see, everywhere in the definition, in many of the provisions and you will find that the word used is as may be prescribed. Please take a note of this particular point. जहाँ पे भी जिस प्रोविजन में भी अगर ये चीज ये फ्रेज मेंशन है as may be prescribed, तो सिंपली आप देखिए जाइए डेफिनेशन क्लॉज जो हमारा सेक्शन 2 है ऑफ द कंपनीज एक्ट 2013. It says under clause 66, it specifies that prescribed means prescribed by rules. Okay, made under this act, and rules are prescribed by the central governments. तो यहाँ पे क्या है, जो भी रूल्स में प्रिस्क्राइब्ड है और जहां पे भी ये टर्म यूज्ड है वहां पे आप उसके लिए रूल्स को रेफर करेंगे. और आप सबको पता है जो एक्ट होता है इट लेज डाउन द रेगुलेशंस, एक्चुअली रूल्स एंड रेगुलेशंस, व्हाट इज द एक्ट. एंड जब हम प्रोसीजरल पार्ट की बात करते हैं या कंप्लायंसेस की बात करते हैं तो डेफिनेटली देयर वी नीड टू रेफर द रूल्स. तो इसके लिए अगर जब आप कोई प्रोविजन पढ़ते हैं एंड यू नीड टू रिक्वायर अबाउट द एक्सप्लेनेशन और द डिटेल्स or the compliance part, in how many days and how that can be done, who can be the persons they can do this task and they can do that work. Everything can be seen into the rules part. So when you read the Companies Act, you need to read everything. You need to read the act. Okay, you need to see that schedule, and of course they are divided into chapters, so that is a different thing. And this is and last but not least, that is the rules.
So whenever it is written as may be prescribed, you have to see the rules. If the central government has notified a respective rule related to it, it will be applicable. And if it hasn't still given a rule for it, but it has the power that in future it may prescribe a certain rule relating to as may be prescribed.
Absolutely. And what was the major thrust of this Companies Act? When this Companies Act was enacted, so there was some thought process of the lawmakers. So they were made focusing on to improve the corporate governance in order to facilitate entrepreneurial and prudent management so that it may deliver the long-term success to the company. Further, they focused on the simplified regulations and also to strengthen the interest of the investor. So these are the main thrust on the basis of which our Companies Act 2013 has come into enforcement. Now, this was just the general introduction about the Companies Act 2013. Now, let's start up with our chapter. Our chapter starts with section 1, which deals with the title, extent, commencement and application.
So, dear students, since we are receiving a lot of queries with respect to one thing, which is to have the PPTs or the notes. We will be discussing the notes with you. Apart from that, as we have told you before also, that before coming to the lecture, it is expected that you have already read once the chapter. Since in the initial stage, in the last class, we told you that if you have read the chapter on your own once, like a novel, it will be much easier for you to understand. However, if you still haven't read the chapter, we are just sharing the notes with you in the form like live notes only. For your convenience, we will be uploading these notes in a day or two. Apart from that, a student is asking that Yogita Kumar, ma'am, weightage of this chapter. If we see the skill-wise and section-wise weightage, out of the 60 marks portion, in part 1, we have 4 chapters, which is preliminary, then incorporation, then prospectus, and then share capital. So it's 4 chapters, and the weightage would be somewhere around 15 to 20 marks for all of these chapters. So we cannot tell you in short that how much marks this particular chapter will carry. Rather, we can tell you that out of these 4 chapters, 15 to somewhere like 30 or 35 marks can be asked from these 4 chapters. So there is not exact weightage assigned to this particular chapter. It's for a particular section.
And one query that has been raised by the students regarding that, Jayendra Kumar, he's asking any tip for boosting law terminology for perfect answer. Dear students, you should keep on reading and reading and reading. Then only you'll be able to have a grasp on the language. And there are the terminologies you need to read in a simplified manner. You have to break the complex terminologies or the definitions into a break. And in fact, if required, you can prepare your own notes for understanding. You can either lay down in the bullet points, or you can just lay down the important points, or you can draw the table, or whatever the manner that you adopt. And it is not feasible in every sort of the definition, but yes, some of the complex definition, you can make the main points. And then you just read that and revise every time so that you can have a good grasp on that particular definitions of the law terminologies.
So one student, Suyog Joshi, I will keep in mind that your name is Sahil Joshi, because we come to know only the names that are being given here. And apart from that, I would like to say law is an interesting subject if you want to take interest in it. If from day one you are feeling it's a boring subject, you will definitely feel bored with it. हम आपको ऐसे पढ़ाएंगे कि आपको बोरिंग ना लगे. Sorry, that depends on your attitude also. But we will try our level best कि इस सेशन से एटलीस्ट आप 5 definitions आज ही समझकर याद करके जाए. अगर आज ही आप एटलीस्ट 5 definitions भी लर्न कर लेते हैं, यहाँ से उनके कीवर्ड्स आप लर्न कर लेते हैं, तो इस सेशन का मकसद फुलफिल होता है. So if you learn 5 definitions also, your 2.5 hours will be fruitful, and we will try our level best to give you the best what we have. So be patient, try to be in tune with whatever we are telling you, and please take out your study material or whichever detailed book you are having with you, because bases have to be from yourself. So starting with the session, so this is our chapter 1 preliminary. Introduction, we have Nisha ma'am already told you. Preamble, she has already told you. And apart from that, we have short title, extent and commencement of application. So what do we mean by short title? Mera naam kya hai? The short title gives the name of the act. Extent, kahan tak applicable hoga? The area of applicability of the act. And commencement, from which date it is enforced. So section 1 deals with the title of the act, and the title, the name of the act is the Companies Act 2013. For the extent, that is the area of application, it is the whole of India. We say the Companies Act 2013. It is made in India. It is for the companies of India or which has a nexus with India. Nexus means आपका कोई relation, if something has a relation, if some company has a relation with a company in India, or it has some outside country has a relation with India, nexus should be there. Then in that case, that company will be treated as an Indian company or foreign company. We will be dealing with that also. So nexus is there. So it is applicable to the whole of India, to all the states of India. This act is applicable. This act is applicable. Sorry. Commencement of the act. Nisha ma'am told you that section 1 of this act was enforced on 30th, 30th August 2013. However, they said that different dates were given for the enforcement of different provisions of the act. Why the date of enforcement is important? Is it necessary for students who are appearing right now to know the different dates that were given for the different provisions? No, because right now all the 470 sections are enforced. Like if you see from 2013, we are standing at 2022. So almost 9 years have passed. So it's not important for you to remember that what was the date of enforcement of such and such section. However, since it's part of the act, so we are telling you. If I say this with respect to the sections, this line is correct. But if I say with respect to the rules, date of enforcement still makes a sense to me. Suppose, I am just giving you an example. Let's say rule 35 of the Companies Incorporation rules has been newly brought into force, has been newly published, but it hasn't published in the official gazette. But they have said that it will be enforced from 2nd April or let's say 2nd November 2022. So they have already given a date which is quite a time after where we are standing today. So though you have the provisions, you know the provisions of that rule. However, its applicability date will start from 2nd November 2022. Before that date, all the provisions of that rule, if it is an old rule, which are there right now, they will be applicable. But after 2nd November 2022, only the new rule will be applicable. So the date of enforcement with respect to sections or rules become important.
Even the CARO, it has been made, earlier it has been made applicable for 21, but later on, now again that has been taken back and now again it has been most applicable from this April 2022. So this is how they can do, they can make at any point of time the different provisions to be applicable. And one more thing, when as Shraddha said, with respect to extent of the Companies Act, that they are applicable to the whole of this India. But in most of the act, you will be seeing that there has been specified except Jammu and Kashmir. But here, since whole of India is mentioned, that means including Jammu and Kashmir.
So now, for most of the acts, this even Jammu and Kashmir has been removed. So most of the acts are now applicable to the whole of India. So just keep that thing in mind. And then we are saying applicability of the act. So what do we mean by applicability of act? ये कौन सी companies पे applicable? To which of the companies this is applicable? So number 1 is the companies incorporated under this act. That is the Companies Act 2013. Or in any previous company law, like we told, if any company was incorporated under the Companies Act 1956, or even prior to that in 1930, or even prior to that, the Companies Act 2013 will still be applicable. We have given it an example. Suppose there is a company ABC which was incorporated in 1972. So obviously it was given under the it was incorporated under the Companies Act 1956. But because of this applicability, it will be, the Companies Act 2013 will be applicable on this ABC Limited, though it was formed under the Companies Act 1956. So the next what we have, see, we have given you a few things like, let's learn it. कौन सी कंपनीज पे एप्लीकेबल है? कंपनीज incorporated under this law, that is Companies Act 2013 or any previous. There will be obviously some more companies, insurance companies, then banking companies. ये दोनों अपने ही एक टाइप की कंपनीज है, फाइनेंशियल कंपनीज, ठीक है, इंश्योरेंस, बैंकिंग कंपनीज, then companies engaged in generation of supply or electricity, and any other company governed by any special act. Then the F part is such body corporate incorporated by any act for the time being in force as the central government may specify. This line, as the central government may specify, ये आपको बहुत जगह मिलेगी. उसका रीजन क्या होता है? सेंट्रल गवर्नमेंट बहुत बार बहुत सारी पावर्स अपने पास रखता है. So यहाँ पर उन्होंने, here they have told that any body corporate incorporated by a special act which the central government will tell you. Apart from that, the way of learning is, if you see the common thread between all these companies is that they have their own special acts. Insurance company has the IRDA Act. Banking companies have the Banking Regulation Act. Then the companies engaged in this electricity and supply has their Electricity Act. And then they have said that any other company which is governed by a special act. So special acts company, they have said that they will apply to these companies. The Companies Act 2013 will apply to these companies. Now, if you see, we have given something in this box, except in so far as the said provisions are inconsistent with the Insurance Act 1938, Banking Regulation Act, Electricity Act और Special Act. ये एक लाइन आपको सिर्फ पूरे उसमें याद करें. You have to learn only this line, because when you will be writing the answer to if such question, you have to write insurance companies except in so far as the said provisions are inconsistent with the provisions of the respective act. If you don't remember Insurance Act, write just respective act. So it is applicable on companies incorporated under this act or the previous law, insurance company, banking company, electricity generating companies, then governed by special acts or body other body corporates incorporated by any act which have been notified as such by the central government.
अब जैसे बच्चे ये पूछ सकते हैं कि any other company governed by special act ये क्या है, तो मैं आपको ये बताऊंगी, these are known as the statutory companies. जैसे कि हम एग्जांपल ले सकते हैं आरपीआई का, एलआईसी का, because special act establish these kinds of the companies. Okay, and when we talk about the other point, any body corporate incorporate by any act, तो यहाँ पर जैसे कि आप एग्जांपल देख रहे हैं नोट्स के अंदर एफसीआई का, तो आप देखेंगे कि एफसीआई इज ए स्टैट्यूटरी ऑर्गेनाइजेशन कॉन्स्टिट्यूटेड अंडर द फूड्स कॉर्पोरेशन एक्ट 1964, यानी कि वो जो स्पेशली इनकॉर्पोरेटेड है बाय एनी एक्ट. तो यू आर सीइंग इट हैज बीन इनकॉर्पोरेटेड अंडर अ स्पेसिफिक एक्ट. और ये जो होते हैं इस तरह के बॉडी कॉर्पोरेट को, इसको सेंट्रल गवर्नमेंट नोटिफाई करता है विद रिस्पेक्ट टू दैट whether the Companies Act 2000 will be applied on it or not. तो यहाँ पे क्या होता है कि जनरली अगर आप देखोगे कि जितनी चीजें बताई हैं, इन्होंने ये इसका क्रक्स ही बताया है कि जो आपके स्पेशल एक्ट्स होते हैं वो हमेशा प्रिवेल करते हैं ओवर द जनरल एक्ट. और यहाँ पे जो जनरल एक्ट है, इट इज द कंपनीज एक्ट 2013, बिकॉज इट टॉकिंग अबाउट एवरी कंपनी, किस किस कंपनी पे एप्लीकेबल होता है. और अगर कंपनीज एक्ट जो कि सभी कंपनीज पे एप्लीकेबल है, पर अगर वो इनकंसिस्टेंट है विद द प्रोविजन ऑफ दीज एक्ट अंडर विच दीज कंपनीज आर रिलेटेड, दैट मींस अंडर द स्पेशल एक्ट, देयर the provisions of the Special Act will prevail. This is the crux of what text is given in the box. तो आप समझ जाइए कि हमेशा Special Act prevail करता है over the General Act. So this is what given in the box.
And that is also a rule of interpretation.
बिल्कुल, आप जब interpretation का chapter पढ़ेंगे, तब आप ये rule भी पढ़ेंगे.
So a student has asked about the difference between, let me just see who's the student. Aditi Bhatti. No. It's like I'm not able to get the name of the student. So what is the difference between, say, this is Vanati V. What is section, subsection, subclause? Okay, just let's explain it to them in short. Like we are saying that the Companies Act 2013 is divided into 470 sections. So if I say there is a section 4, then under that we will be having a subpart which is known as subsection. Section से छोटा, section का एक part. So then there is subsection. Then under this subsection there will be a clause. Then under this clause there can be further something which will be a subclause. So how this will be written? So it is section 4, subsection 1, clause A and subclause 1.
एक फॉर एग्जाम्पल दे सकते हैं. इनफैक्ट जो ये बच्चे पढ़ रहे हैं उसी का एग्जाम्पल देते हैं. अगर आप देखो हम सेक्शन 1 यहाँ पे आपको पढ़ा रहे हैं, तो दिस इज द मेन सेक्शन, सेक्शन 1. एंड इफ यू आर सीइंग further the extent, commencement and application, so this is subsection 2, subsection 3 and subsection 4. If you can see, so this application, so how you can write down, if you just want to write down about the commencement, suppose, so you will write down section 1. Okay, then they said about the point number 3, subsection 2 is there or 3, let me check, it is 2 or 3, I need to see. It is 3. Okay, that is subsection 3, and then that clause,
then clause A, B, C, D.
These are all the applicability of the act. So you can see here is these are the clauses: section, subsection, and then clauses. So you will read as section 1, subclause 3, or subsection 3, and clause A. So this is how you can read and make a differentiation with the section, then subsection, then clause, subclause, and so on.
So, with respect to this box, we have explained you that why we have given it separately. In acceptance, so far as the set, as one student has asked us to explain it once again, acceptance so far as the set provisions are inconsistent with the provisions of the respective act, the Special Act will always prevail over the General Act. So, this was one thing. So, as you are reading that section, how many subsections are there or clauses are there in the definitions?
First, let me tell one thing, that definition clause is section 2.
Okay, good. So,
okay,
section
this is
2.
section 2. And further in section 2, there are numbers of definitions that has been kept under different numberings. So here that numberings shall be read as subsection. And further, if there is any bifurcation of that subsection in either in point 1, 2 or 3 in the main part of the subsection, then it will be set as a clause. Okay.
But many a time when you say about the definitions, we say that there are 95 clauses. Definitional section is the only exception in the whole of the act where subsections is many times referred as the clauses. So it is an exception.
Yes.
But for the ease, we will be saying subsection, and sometimes we will be using the term as section 211. So it doesn't mean 211, it means section 2, subsection, or rather clause 11.
Yes. So when we talk about the definitions, so you will be seeing that why is the need of a definition in any of the act. So in fact, the various terminologies or the definitions which are frequently used in the act, actually they help us to understand the meaning of the word or the phrase used over there as it is intended in the act to be used. Means it has given a certain meaning to it, and that meaning should only be taken into consideration while interpreting or construing any of the legal provision if the term is used over there. And in fact, these definitions are also known as internal aid. So this is definition is also known as internal aids to construction.
Detail you will read in the chapter 4, interpretation of statutes.
Yes. So they give immense help in interpreting or construing the enactment or any part of the act. अगर if you see now section 2 का ही जो आपका आप subsection का या clause का as already we have told you, though here the clauses word is used, so you can take it as clause 95. ये बात कहता है, ये कहता है कि कोई भी वर्ड या एक्सप्रेशन जो यूज किया गया है इस एक्ट के अंदर पर वो इस एक्ट में डिफाइन नहीं है. It is used in the act but not defined in this act, but it is defined in some other acts. For example, in the Securities and Contract Regulation Act, or in the SEBI Exchange Board of India Act, or under the Depositories Act 1996. There it shall have the same meaning respectively as it is assigned under that act.
So if something is not defined under the Companies Act 2013, but that word is being used in this act, that is the Companies Act 2013, then we can take the meaning of that word from the SEBI Act or the SCRA Act,
Depositories
or
Act.
the Depositories.
बिल्कुल. तो ये आप समझ लीजिए कि ये आपको क्लॉज ऐड ही इसीलिए किया गया है क्योंकि कुछ टर्मिनोलॉजीज आएंगी तो आप कहेंगे अरे ये तो एक्ट में कहीं डिफाइंड ही नहीं है, अब हम इसको कैसे इंटरप्रेट करें. तो ऐसी कंडीशन में आपको रिस्पेक्टिव जगह पे जाना पड़ेगा जिससे कि आप उसको वहां से उसकी डेफिनेशन को समझ के उसको उस इंटेंट से जिस वे में वो डिफाइंड है उसको आप इस एक्ट के रिलेशन में रीड कर सके.
Janesha, yes, you are correct. So it's like this subsection 1 is a clause, but for ease in the Companies Act we can change interchangeably as subsection or a clause. And this A, B, C, D are clauses. Yes, because that was section 1. This is Suyog. I think I have read your Sahil Joshi. Sorry. Sahil Joshi. Yes, this is these are clauses because it was with respect to it was with respect to section 1. One more thing, students, like in this we might have used it as A, B, C, D, but you need not remember that much because it is not practically possible. And when we are studying from the study material, since we would not be reproducing the whole of the bare act, and for ease we might break a point or we might change the sequencing or the numbering for better understanding of the students. So if you have to read the exact that what is section 1, subsection 1, subsection 1, clause A, you should always have a copy of the bare act or you can refer it from the website MCA's website. So you can refer it from there also.
और हम फिर ये कहेंगे कि बेयर एक्ट आप जरूर रीड करिए क्योंकि जब आपको मेन सेक्शन याद करने होते हैं तो देयर आल्सो इट हेल्प्स एंड बिसाइड दैट व्हाटएवर नोट्स आर गिवन साइड बाय साइड वी आर मेंशनिंग द सेक्शन एंड सबसेक्शन सो दैट while reading and
we have mentioned everything for your convenience, but then
so that, yes, so that whenever we are reading that particular section, so you can also see there that we have given the particular section number. So that reading, every time reading will definitely make us to retain that section. तो इस तरह से हमें कोशिश करनी चाहिए हम बार बार उस चीज को पढ़ें. और अगर आप पहले ये सोच लेंगे कि यह सेक्शन तो मुझे याद ही नहीं होता, मैं तो याद ही नहीं कर सकता, और पहले अगर आपने ये सोच लिया कि भैया मैंडेटरी तो है ही नहीं,
एंड तो इस चैप्टर में आपको 211, 213 इतना याद करने की जरूरत है सच नहीं है. बट मेक अ हैबिट लाइक व्हाइल यू विल बी रीडिंग द डेफिनेशन से अकॉर्डिंग टू सेक्शन 211 body corporate this or 213 or 212. If you have that habit, you will somewhere remember.
और नहीं चलो 100% रिमेम्बर रखेंगे तो कुछ तो रखोगे, 50% तो याद रखोगे, और हो सकता है वही आपको फायदा दिला जाए.
So before going further with the exact definitions, let's explain one more important thing with respect to the definitions.
Yes, when a word or phrase is defined as having a particular meaning in the act, in the enactment, then it shall be considered with that particular meaning only. तो इसलिए हम जो डेफिनेशन क्लॉज को इसलिए इंट्रोड्यूस करते हैं एक्ट के अंदर, सो दैट आप उसका डिफरेंट इंटरप्रिटेशन ना निकालें. लेकिन यस, इफ देयर इज एनी कॉन्ट्रडिक्शन, तब वहां पे हम हेल्प लेते हैं इंटरप्रिटेशन के प्रिंसिपल्स की, कि हमें उसको किस कॉन्टेक्स्ट में उसको इंटरप्रेट करना है.
So if the word member is used, or if the word officer is used at many places in the Companies Act 2013, and if we come back to the definition section, that is section 2, we will see we have a separate definition for member, officer. Then we will be referring to that particular definition only. And so that word, since it's appearing at many places, and we don't repeat the same definition again and again, so we give it under section 2 at one place.
इससे क्या होता है कि इट ऑल्सो प्रोवाइड अ की टू द प्रॉपर इंटरप्रिटेशन ऑफ द इनैक्टमेंट. एक तो आपको ये मिल जाता है कि हाँ, हमें इसको इसी तरह से इंटरप्रेट करना है पूरे एक्ट के अंदर. और दूसरा चीज होता है कि ये आपकी क्या लेंथ को भी शॉर्ट करता है.
एक्ट की लेंथ,
बिल्कुल, क्योंकि आपकी मतलब इन द सेंस लेंथ. हाँ, क्योंकि क्या होता है कि एवरी टाइम वरना आप हर बार वो टर्मिनोलॉजी को डिफाइन करेंगे एट वेयरएवर दे आर बीइंग यूज्ड अंडर द लीगल प्रोविजन, तो इट विल डेफिनेटली इंक्रीज द लेंथ. So in order to that, it will also reduce the size of the act. तो इस तरह से इसको हम इसकी रेलिवेंस समझ सकते हैं कि डेफिनेशन सेक्शन क्यों दिया जाता है. इवन आपने कई बार डेफिनेशन में देखा होगा कि देयर आर सर्टेन वर्ड्स यूज्ड आर लाइक इंक्लूड्स, जस्ट मीन्स,
and this thing will help you in further reading of definitions. So please keep a note of it.
Yes. तो आपने देखा होगा मोस्ट ऑफ द डेफिनेशन पे ये डिफरेंट टाइप्स ऑफ टर्मिनोलॉजीज बीच बीच में यूज होते हैं, वर्ड्स यूज होते हैं लाइक इंक्लूड, मीन्स, इंक्लूड एंड मीन्स, एंड देन यू कैन सी टू अप्लाई एंड इंक्लूड. तो इन वर्ड्स और फ्रेज का क्या मतलब होता है, हाउ यू कैन इंटरप्रेट व्हेन दीज वर्ड्स आर यूज्ड इन द डेफिनेशन. जब हम वर्ड यूज करते हैं मीन इन द डेफिनेशन, सो दैट इंडिकेट्स रिस्ट्रिक्टिव. दैट मीन्स it puts a restriction on the meaning of the word. वो उसकी मीनिंग को रेस्ट्रिक्ट कर देता है that what is given in the definition.
That is, जितना हम आपसे बोल रहे हैं, डेफिनेशन कहती है मैं जितना बता रही हूँ आपको उतना ही समझना है. Whatever is written, you have to take the meaning only to that extent.
और वो अपने आप में कंप्लीट माना जाता है, आपको फिर कुछ और उसके बाहर देखने की जरूरत नहीं है. So this gives prima facie, you can say, restrictive and exhaustive interpretation of the definition. जब हम बात करते हैं include की, wherever the term include is used in the definition, it indicates the meaning extensive. Extensive का क्या मतलब होता है? Wider and considerable extent. इसका मतलब that definition is not restricted to the meaning assigned to it, but has extensive meaning. यानी इसका wider meaning है, beyond wider meaning, जो उसमें नहीं दिया वो भी, और जो दिया हुआ है including वर्ड अगर यूज है तो वो भी उसके अंदर कवर्ड होगा.
तो अगर हम समझें तो मीन्स कहता है जितना बताया गया है उतना समझो, उतना ही लो. और इंक्लूड्स कहता है कि जो आपको पता है वो तो है ही, उसके अलावा जो मैं कह रहा हूं वो भी है.
और फिर आता है मीन्स एंड इंक्लूड्स. तो अगेन यहाँ पे इसका मीनिंग होगा सेम एज इट विल बी एग्जॉस्टिव, यानी कि जो हम मीन्स का बताते हैं उसी तरह से मीन्स एंड इंक्लूड्स के अंदर, यानी कि कंप्लीट इन इटसेल्फ, आपको उसके बियॉन्ड बाहर जाने की जरूरत नहीं है. सिमिलरली टू अप्लाई टू एन इंक्लूड, वहां पे क्या होता है, दैट डेफिनेशन इज अंडरस्टूड एज एक्सटेंसिव, सेम एज दैट व्हाट वी हैव गिवन अंडर द इंक्लूड, यानी कि बियॉन्ड what is given, apart from what is
not you understand in the common pattern.
तो जो दिया है वो तो है, जो नहीं है वो भी आपको कंसिडर कर लेना है, उसके अंदर वो आता है नहीं आता है ये देखना है. बट यस, दैट डेफिनेशन विल इंक्लूड दैट पार्ट ऑल्सो. तो ये तो हमने आपको जनरल इंटरप्रिटेशन बताया कि अगर कंपनी ये डेफिनेशन में अगर इस तरह की टर्मिनोलॉजीज यूज होती है तो हाउ यू आर गोइंग टू रीड एंड इंटरप्रेट द टर्मिनोलॉजीज यूज्ड इन द
because definitions obviously you can read and understand, but how to read and understand we are trying to help you with those things. So let's start with our the main definitions.
इनफैक्ट मैं ये कहूंगी श्रद्धा, यहाँ पे बच्चे देखेंगे ये क्या हमने डायरेक्ट सबसेक्शन 11 से स्टार्ट कर दिया है, तो ये बच्चों को हम बताना चाहेंगे वी हैव ट्राइड टू डू सम सॉर्ट ऑफ एक्सपेरिमेंट एक्चुअली just for the benefit of you students. So what we have done, we have changed the order of arrangement of the sections just by linking one section with the other, the subsection with the other, that in order to connect to you कि कैसे एक टर्म दूसरे टर्म से कनेक्टेड है और किस तरह से आप उसको कनेक्ट करके रीड कर सकते हैं, उसको समझ सकते हैं, जो रेलेवेंट एस्पेक्ट्स है, how they are interconnected and related with each other.
Archie, you have to look for the Bear Act on MCA website. That's what we said, and it is for with respect to this memorizing of sections and all those things. Request you to please see the previous lecture.
Poonam Sharma is also asking what is the meaning of commencement. पूनम ऑलरेडी कहते हैं कमेंसमेंट का मतलब होता है किस डेट से वो एक्ट आपका एनफोर्स होगा. हर एक अगर आप कोई एक्ट देखेंगे तो उसमें प्रॉपर्ली कमेंसमेंट डेट दी हुई होती है कि किस तारीख से इस एक्ट को आप इफेक्टिव मानेंगे, किस तारीख से ये एक्ट एप्लीकेबल होगा. फाइन, तो दिस इज द कमेंसमेंट डेट. पर्टिकुलरली विद रिस्पेक्ट टू कंपनीज एक्ट, ऑलरेडी सेड इट हैज नॉट बी commenced the entire act at once, but it has been made in a phase wise manner. तो आपको commencement से तात्पर्य सिंपल है from which date the act is going to be enforced.
And Janesha, you have asked that, ma'am, what is the meaning Bear Act? Bear means the act as sorry, this is Jayendra Kumar. Jayendra Kumar, you have asked that what is a Bear Act? It is B-A-R-E. Let me just write it for you. It's not Beer Act. It's Bear Act. Just a moment. So it's Bear, B-A-R-E, Bear, as it is, and it is on MCA website. MCA website क्या है? जरा Google कीजिए. Take a bit of a help of your Google Baba. We can tell you. Please थोड़ा सा finding की habit आप अगर अभी आप लोग search करने की habit डालेंगे ना, we are here to help, but try to help yourself also, so that you inculcate the habit of reading. एक वो पैशन होता है ना कि हमें पैशन होना चाहिए कि मुझे ये चीज पता होनी चाहिए. So thank you for raising such queries. Then one student has asked the meaning of prima facie. Prima facie.
Yes, it is raised by Janesha.
So it means what appears to be at the first instance. It may be true or not true, but पहली बार में आपको क्या समझ में आता है? What appears at the first instance
means from the very beginning. This is the prima facie. Because आप कह रहे हैं आपने न्यूज़पेपर में पढ़ा है, तो मीन्स वही जो आपने वेरी बिगनिंग में जो देखा, जो आपने फर्स्ट इंस्टेंस में आपने देखा, वो चीज आपको जो देखते ही पता चला, दैट इज prima facie.
मैम, why definitions are not in series? मैम, मेरे प्यारे प्यारे बालकों, इसका सिर्फ इतना सिंपल सा रीजन है. पहली बात तो थोड़ा सा पेशेंस. द थिंग इज वी हैव, इफ इन द एक्ट थिंग्स वर गिवन alphabetically for the ease of finding the definition. Like if you are in the chapter of memorandum and if you see they have used the word alteration or alter, then you know alter and you will directly go to the definitional clause, and it means it is starting from A. So it's for the ease of finding. It's given in the alphabetical order under the Bear Act. However, here what we are doing is we are trying to give the definitions to you in such a manner that you are able to have a linkage of the different definitions, or there is a proper sequencing which helps you to remember the definitions, that okay, a company is formed or what are the type of companies. So we have tried to make order of our own, which may help you. That's an experiment, and definitely it will work for you because it has worked for many. So it will, though it is an experiment, but it's an experiment for the new batch, but for the previous batches it might not be an experiment.
और यहाँ पे भी इंटेंट देखना चाहिए. हमारा इंटेंट है कि आपको बेनिफिट मिले. As like the intent of हम law देखते हैं, here also you should see what is the intent behind such an experiment, just to give you benefit, in order to make it easily relate with each and one of the sections, so that can help you in easily retaining of the sections and recalling of the sections, as well as connecting with the other relevant definitions. इनफैक्ट आप यहाँ देखेंगे 95 क्लॉजेस है, तो स्टूडेंट वक्त देखें हाय इतने सारे क्लॉजेस पढ़ने हैं, हम कैसे पढ़ेंगे. तो भाई अब यही बात कही जाएगी आप लोगों से कि हमने यहाँ पे सारे क्लॉजेस ना हम आपको बताएंगे, ना हमारे हिसाब से हर एक क्लॉज आपके लिए रेलिवेंट है. यू कैन जस्ट गो थ्रू वंस एंड देयर यू कैन जस्ट लिव इट, बट व्हाट आर द रेलिवेंट. रेलिवेंट से तात्पर्य ये होता है कि वो इंपॉर्टेंट है, क्योंकि आप कंपनीज एक्ट कर रहे हैं, तो देयर आर सर्टेन टर्मिनोलॉजीज which are very much related and very much used in the company that. तो आपको इसलिए हमने यहाँ पे जो भी रेलिवेंट और इम्पोर्टेंट डेफिनेशन है उसको कवर किया है. पर हम आपको पूरी डेफिनेशन पढ़ाएंगे भी नहीं, वो आप खुद पढ़िएगा. हम खुद चाहते हैं कि आप लोग खुद पढ़ें, खुद अपने आप सेल्फ आगे बढ़े. हम सिर्फ यहाँ पे आपको गाइडेंस देने के लिए है. वी आर जस्ट हियर टू गाइड यू. और याद रखिए, गाइडेंस एंड हार्ड वर्किंग, योर्स हार्ड वर्किंग विल डेफिनेटली आपको सफलता की सीढ़ी तक ले जाएगा. तो प्लीज हमारे साथ जुड़े रहिए. हम अब आपको डेफिनेशन क्लॉज की तरफ ले जाएंगे.
Okay. So many of the definitions which are not being covered here, they will be covered at the respective chapters, and the tutors or the faculties who will be taking your respective chapters will be definitely covering with you wherever required those definitions. So let's start. Since long we are talking Companies Act, Companies Act, Companies Act. Companies Act applicable किस पे होगा? कंपनी पे. तो सबसे पहले अब हम यही देख लेते हैं. So let's start. What is a company? Section 2, subsection 20 has simply defined company as a company incorporated under this act or under any previous law. यही लाइन तो हमने थोड़ी देर पहले भी पढ़ी है. We have just read this line at the time of the application. So, company. Then there is one more term related to companies which you must have heard time and again. Body corporate or corporation. अब आ गया यहाँ पे हमारा प्यारा includes. So here we have our includes which we just read. What you know is already there, but the act is saying something more which you should know. That is, a body corporate will include a company incorporated outside India. अब इंडिया के बाहर जा चुके हैं. Now we have gone outside India. But is it applicable on all the companies incorporated outside India? I will give it just a bit of a word. It will have whenever it has a nexus with India, then only that it will be treated as a body corporate. But how that nexus will be decided, that's altogether a different thing, and you will read it at final year.
It is covered under different chapters.
Yes. So company incorporated outside India now, but it does not include. Include भी कर दिया और does not include भी करा. It has included something specifically. It has said body corporate includes company incorporated outside India, but it does not include. Does not include body corporate के सेंस में क्या कह सकते हैं? कुछ ना कुछ तो स्पेशल उसे गवर्न कर रहा होगा, जो हमने सेक्शन 1 में भी देखा. When in this case, there will be something special, an act which will be specially governing something. So what are, which it does not include is a cooperative society. So we have a cooperative societies act. Then, and any body corporate which the central government by notification specify in this behalf. So the central government has again kept some powers with itself. It has the power that it may say that such and such body corporate or such as such company will not be treated as a body corporate under the Companies Act 2014. The central government is very smart. It always keeps some of the powers with itself, which at a relevant time it may tell the general public through the rules. So, this definition 211, body corporate includes, what do we say? Outside India, companies incorporated outside India, does not include cooperative society. You know the why, because it is governed by a special act, and other body corporates which the central government will notify. Done. So we have covered this definition also. I think this example is very clear with you because we have read something like this before also. Still, we have given this example and incorporated under this act or under any previous law. Suppose this Reliance Industries was incorporated in 1973, Tata Steel was incorporated in 1907, and this Infosys was incorporated in 1981. If this line was not there, this definition was not there, company means a company incorporated under this act. If it would have stopped here itself, then Reliance, Tata and Infosys would have been outside the purview of the Companies Act 2000 because they were incorporated under the previous law. So, the companies that were incorporated even before this act, that is 2013 act came into existence, they have also been brought under the purview of the Companies Act 2013 with the help of the words or under any previous law. So, company incorporated under this act or any previous company. We are talking company. Company बनाता कौन है? Company के लिए सोचता कौन है कि ऐसी company बनाई जाए? So, a person who thinks that, okay, I want to make a company. There is a person known as promoter. There is a person, let's keep the word promoter a bit. There is a person who thinks to form a company. It is he who conceives the idea that, okay, I want to form a company. That person thinks to form a company, conceives the idea, okay, I want to open such company, and who takes the steps for the registration of the company. So there are three things. You need to think, you need to work for it, and who takes steps for the registration of the company. That person is known as the promoter. Okay. So what I told you about the promoter is a general thing. If I am a promoter, suppose I am the promoter, how will you know I am the promoter? Because if I have formed a company A Limited, you will not come to know that I have formed that company. So either Shraddha will be named as a promoter in the prospectus. So I will be named as a promoter in the prospectus, or I will be identified as a promoter in the annual report. या तो मेरा नाम लिख देंगे वो लोग as a promoter कि मैं promoter, Shraddha is a promoter of the company. Yeah, I will be identified as a promoter in the annual report. Once then I have formed the company. Should I have ये कि मैं promoter हूँ? कैसे? I will have a control over the affairs of the company. Control over the affairs of the company, whether directly or indirectly, चाहे as a shareholder, director or other. मेरा control होगा over the affairs of the company. And the third, obviously I like power. So Shraddha will have the directors of the company will act according to my advice, my directions, or my instructions. So, then I will be treated as a promoter of the company. Definition आप सब पढ़ सकते हैं. याद कैसे करनी है? Shraddha, take your name. I will be named as a promoter in the company, in the prospectus of the company, or I will be identified as a promoter in the annual return, or my actions will show. My actions will show in two ways. One is I will have control over the affairs of the company, directly or indirectly, in the form of a director, shareholder, or otherwise. किसी और तरह. Otherwise means in any other sense. Or my second action would be the board of directors who will be conducting the affairs of the company will be acting according to my advice, my directions, and my instructions. So I am the promoter. But
एक एक्सेप्शन है, अगर बच्चे ध्यान से पढ़ें कि सब क्लॉज सी का एक एक्सेप्शन है कि अगर पर्सन ने प्रोफेशनल कैपेसिटी में कोई भी एक्ट किया है, that has provided any sort of advice, direction or instructions to the board of the director, तो उस चीज को हम प्रमोटर के उसमें काउंट नहीं करेंगे. यानी कि प्रमोटर के लिए जो 3 रिक्वायरमेंट है that is okay, but this is said that when that person in the primarily in the professional capacity, if he advises or give the instructions to the board to act on it, then he shall not be considered as a promoter.
Why this proviso? Proviso matlab exception. Proviso, provided that word means an exception to whatever was written before that. So this what is the intent behind this proviso? To give a leverage to you people, to me, to any advisor of the company. The board of directors might be taking advice from you because you are a chartered accountant, but they will be, or the board of directors may be taking your advice and they will be acting on your directions. But the intention with you is not to control the affairs of the company. So you, chartered accountant, or any person for that matter, has been given an exception that you will not be treated as the promoter. So we have learned that what is a promoter. Now, this definition, 255, member. Why are we reading this member definition here? Because in subsequent sections and the type of companies, you will see that member word is used again and again. So in the definition itself, use of one of the definitions is being done. So member in relation to a company means the subscriber to the memorandum of the company who shall be deemed to have agreed to become member of the company on its registration shall be entered. Before starting with full of the definition, एक line इसमें याद रख लेना. Shall be entered as a member in the register of members. Just remember this line. Rattle. Shall be entered as a member in the register of members. अगर register of members नहीं होगा तो depository का register होगा. Simple. You will remember this definition. So, moving further, who is a member? Who is the subscriber to the memorandum of the company? Subscriber, क्योंकि memorandum में लिखा होगा. और क्या होगा जब वो कंपनी फॉर्म होके रजिस्टर हो जाएगी तो रजिस्टर ऑफ मेंबर्स में उसका नाम. सो सब्सक्राइबर टू द मेमोरेंडम, देन व्हेन द कंपनी इज फॉर्म ही शैल बी एंटर्ड as a member in the register of members. Point number 1. Then every other person who agrees to be a member in writing and to become a member and whose name is entered in the register of members. 2 points. Third, every person holding shares of the company, member का काम ही क्या? Obviously, they should have an interest. They should hold shares or some kind of interest. Shares or some kind of interest in the company whose name is entered as a beneficial owner in the records of the depository. Because now all the shares are not held physically by the company. Yes. Rather, they are held by the depository. So, now depository is the holder, but the name of the members are entered as beneficial. So, if you see, it is very important that the name should come somewhere in the register of the member. Be as a member in the register of members, 2 points. And the third point is as a beneficial owner in the records of deposit. Then let's move further. We have learned that what is a body corporate, company, then who is the promoter and who are the members.
अब हम देखते हैं कि जैसा बताया कि किसी भी कंपनी को फॉर्म करने के लिए हमें मेंबर्स चाहिए एंड ऑलरेडी वी हैव गॉन थ्रू हु ऑल आर द मेंबर्स. अब जब हम टाइप्स ऑफ कंपनीज की बात करते हैं, टाइप्स ऑफ कंपनीज में सबसे पहले लेते हैं हम ओपीसी 1% कंपनी. फर्स्ट लेट्स गो विद द क्वेरी सेक्शन. इज देयर एनी स्पेसिफिक क्वेरी?
The thing is, explain body corporate, other body corporate and all those things. Just wait, we will be going through these things also. And apart from that, a student is asking word to word ही लिखना है सब. If that is the intent, I think nobody humanly can write word to word. And then we would request you to please refer the previous lecture. The answer of such questions is given there.
और जैसे कि जयंत कुमार एनुअल रिटर्न के बारे में पूछ रहे, इट इज कवर्ड अंडर सेक्शन 92. और चूंकि एनुअल रिटर्न का आप डिटेल
स्पेसिफिक सेक्शन है,
यस, डिटेल में आप इस सेक्शन 92 को आप पढ़ेंगे जाकर अपने मैनेजमेंट एंड एडमिनिस्ट्रेशन वाले चैप्टर के अंदर.
एंड साइड कुलकर्णी इज आस्किंग, इज द कंपनी मीन्स व्हिच इज इनकॉर्पोरेटेड इन इंडिया एंड बॉडी कॉर्पोरेट मीन्स ethics is incorporated outside of India? No. We said no. Includes means whatever you understand in common parlance, and then in what is given there, that also you have to make understand. So obviously the company incorporated in India is included in the definition of body corporate. These are different terminologies which are used at different places in the act.
One more query that has been raised by Sai Kulkarni. She is asking, please explain again the body corporate. The second part of the body corporate she is asking. So in fact, we definitely exclude certain kind of the body corporates. So specifically they have referred there what should not be included within the said definition of the body corporate or the corporation. So it specifies the cooperative society and any other body corporate. Means a company which is not defined in this act, but which the central government by notification specify. So except these are the specific kind of the company which has been excluded from the scope of the body corporate or the corporations.
So let's start with the types of companies.
Yes. When we talk about the types of companies, so generally when we see the mostly students know public, private, or they may be knowing about government. लेकिन हमारे कंपनीज एक्ट में तो बहुत सारी कंपनीज हैं टाइप में. अगर आप देखेंगे 1% कंपनी which has been properly defined under section 2 subsection 62, so it says that 1% as the name reveals, 1% से मतलब है company which has only 1% as a member. और इसके रिगार्डिंग जो डिटेल दिया हुआ है कि कंपनी कैसे बनती है, कौन बनाता है, इसमें कौन कौन लोग होते हैं, तो देयर इन दैट केस यू नीड टू रेफर द रूल 3 ऑफ द इनकॉर्पोरेशन ऑफ कंपनीज एंड इंसिडेंटल मैटर्स रूल्स 2014. और ये चैप्टर आपका हमारे अगले सेशन में कवर होगा. तो देयर दिस पर्टिकुलर कंपनी विल बी टेकन इन डिटेल. दो वी कैन एक्सप्लेन ओवर हियर, बट उससे क्या होगा कि हम जो जितनी रेलिवेंट चीजें हम वो इस सेशन में फिर कवर नहीं कर पाएंगे. एंड इफ दिस पर्टिकुलर थिंग इज कवर्ड एट द रिस्पेक्टिव प्लेसेस, so there you can easily make out and you can understand these terminologies in a better manner. वहां पे प्रॉपर बताया हुआ है कि 1% कंपनी का फॉर्मेशन कैसे होता है, उसे कौन बना सकता है, एज वेल एज उसके नॉमिनीज कौन कौन हो सकते हैं, प्लस कब वो सीज हो जाती है, कब वॉलंटरी वो कन्वर्ट हो जाती है. तो एवरी काइंड ऑफ डिटेल्स विद रिस्पेक्ट टू द working and operation of the 1% company's constitution is given under the rule 3 of the respective chapter of the incorporation of the companies. क्योंकि हमारी कंपनीज एक्ट में एक खासियत है कि हर एक चैप्टर के लिए उन्होंने सेट ऑफ रूल्स दिए हुए. तो आपको याद करना बड़ा आसान है नाम कि किस रूल में किस चैप्टर को या किस सेक्शन को कौन सा रूल बिलोंग करता है. तो उसके लिए क्या है, सिंपल है, जो चैप्टर का नाम है उसी से रिलेटेड उसके रूल्स के नेम है. अगर आप वही पढ़ रहे हैं शेयर कैपिटल
एंड
डिबेंचर्स का आपका वहां पर रिस्पेक्टिव रूल्स क्या होगा, द कंपनीज शेयर कैपिटल एंड डिबेंचर्स रूल्स 2014। इसी तरह से अगर आप इनकॉर्पोरेशन ऑफ कंपनीज एंड मैटर इन्सिडेंटल देयर टू का अगर पढ़ रहे हैं तो आपका उस कंपनी का नाम हो जाएगा द कंपनीज ब्रैकेट में इनकॉर्पोरेशन ऑफ कंपनीज एंड मैटर इन्सिडेंटल देयर टू ब्रैकेट क्लोज रूल्स 2014। तो वहां पे जो रूल 3 है इट विल deal in detail with respect to one person company, but as of now you just simply understand company which has only one person as a member, so that company will be set to a OPC, that is one person company। आप लिख सकते हैं शॉर्टकट में, लेकिन पहले आप कहीं पे उसका डिटेल लिखे फिर उसको आप इस तरह से लिख सकते हैं, ठीक है, उसका एब्रिविएशन फॉर्म में, और फिर उसको लेटर ऑन आप उसको यूज कर सकते हैं, उसका एब्रिविएटेड जो फॉर्म है उसको एज पर योर कन्वीनियंस इन ऑर्डर टू सेव टाइम आप लिख सकते हैं, उसको यूज इन एग्जामिनेशन और इवन लर्निंग नोट्स बना रहे हैं नोट्स पे यू कैन यूज इट एनीवेयर। फिर आती है बात प्राइवेट कंपनी। तो व्हाट डज इट सेज, क्लॉज 68 सेज कंपनी हैविंग मिनिमम पेड अप शेयर कैपिटल, ओके, एज मे बी प्रिस्क्राइब्ड एंड व्हिच बाय इट आर्टिकल्स। पहला तो उन्होंने ये बोल दिया मिनिमम पेड अप शेयर कैपिटल की रिक्वायरमेंट्स को बताया है, और वो क्या है, एज में भी प्रिस्क्राइब।
कहां भागना है हमें, रूल्स में भागो भागो भागो, एज में भी प्रिस्क्राइब्ड आया तो रूल्स में भागो।
बट एज ऑफ नाउ अगर आप देखेंगे कंपनीज एक्ट में अभी तक इवन रूल्स में भी आपको मिनिमम पेड अप शेयर कैपिटल की कहीं भी लिमिट नहीं मिलेगी। बट यस द गवर्नमेंट इज वेरी इंटेलिजेंट, वेरी मतलब क्लेवर यू कैन से, एज में भी प्रिस्क्राइब लिख के उसने ओपन एंडेड छोड़ दिया है कि whenever it may be required they can use they can prescribe at any time the minimum paid up share capital, but as of now there is no such requirement, no minimum paid up share capital that is prescribed. Then second part of this section says which by it articles, क्या चीज बताएगा अंदर इट्स आर्टिकल, restrict the right to transfer its shares, restrict रोक लगाता है कि यहाँ पे ट्रांसफर ऑफ शेयर्स नहीं होगा। लिमिटेड नंबर ऑफ मेंबर्स बता रखा है 200, लेकिन यहाँ पे एक्सेप्शन है इन केस ऑफ ओपीसी।
क्यों एक्सेप्शन, व्हाई दिस एक्सेप्शन इज गिवन,
बताइए। हाँ, क्योंकि अभी आपको डेफिनेशन बताइए,
इससे ऊपर ही 1% की कंपनी के लिखी है, क्योंकि
आपने बता रखा है क्योंकि वहां पर ओनली
1% इज देयर।
यस, तो वहां पे लिमिट्स की तो बात ही नहीं है, हाँ, मतलब उसमें लगती है कि कितने मेंबर्स होंगे। तो यहाँ पे बाय आर्टिकल इट हैज पुट द टू रेस्ट्रिक्शंस, टू मतलब डिफाइन द टू यू कैन रिक्वायरमेंट। फर्स्ट इज रिस्ट्रिक्टिंग द राइट टू ट्रांसफर इट शेयर्स एंड अदर वन इज लिमिटिंग द नंबर ऑफ इट मेंबर्स टू 200।
Yes, remember this limit of private company limit is 200।
ठीक है, आपको ये देखना है। साथ ही साथ इन्होंने प्रोवाइडेड वर्ड भी ऐड कर दिया इसी के एक्सप्लेनेशन में, इसी चीज को और एलोबोरेट करने के लिए। जो सब क्लॉज 2 है उन्होंने ये बोला कि वेयर 2 or more person holds more than one person hold one or more shares in a company, that too jointly, then in that case they can be treated as a single person। मतलब ये कि कई बार ऐसा होता है कि जॉइंट नेम में शेयर्स होल्ड होते हैं, तो वहां पे आप उनको अलग अलग पर्सन नहीं मानेंगे एंड यू विल कंसिडर देम एंड ट्रीट एज अ सिंगल मेंबर। ठीक है, फर्दर इट सेज दैट
वन मोर प्रोविजन इज
यस, क्या बोलता है वो ये कहता है द पर्सन्स हु आर इन द एम्प्लॉयमेंट ऑफ द कंपनी एंड द पर्सन्स हु हैव बीन फॉर्मली इन द एम्प्लॉयमेंट ऑफ द कंपनी, ठीक है, उनके रिगार्डिंग बोलता है और कहता है shall not be included in the number of members। I'm only reading the crux, आपको कितना उसमें रिटेन करना, बहुत कुछ दिया होता है सेक्शंस के अंदर, बट आपको ये देखना है कि आपको मेन पॉइंट ऐसा क्या है जिसको आप रिटेन करके आप अपना पूरे प्रोविजन का सार वहां पे लिख सकते हैं, समझ सकते हैं, एंड यू विल डेफिनेटली गेन आउट ऑफ दैट पर्टिकुलर राइटिंग द क्रक्स ऑफ द डेफिनेशन ऑफ द प्रोविजन। तो यहाँ पे हमने ये बताया। और तो थर्ड क्लॉज था हमारा, वो कहता है prohibits any invitation to the public to subscribe for any securities of the company, यानी कि कंपनी cannot offer the shares to public for sale। तो आपको मोटा मोटा अगर प्राइवेट कंपनी समझना है तो क्या क्या चीजें आपको याद रखनी है। पहला जो उन्होंने रेस्ट्रिक्शन लगाया है कि आप ट्रांसफर ऑफ शेयर्स नहीं कर सकते हैं,
why they don't want to transfer the shares. As the name suggests, private, closed. So close करने के लिए company को what for in order to keep the company as a closed group, what is needed? Not many members should be there, and if there are members, they should not freely transfer the shares, and more number of people should not subscribe to the shares. Closed is the word. The moment you think of the word closed, you will get in your mind that it want to keep it as a closely held company. So what is that? Limit the number of members as 200. Restricts the right to transfer shares. Don't want to transfer it shares. Third point is prohibits the invitation to public. Because if they give the shares to public, obviously more number of people will enter the company. So whenever you are reading a section, look into the intent, why it is called a private company. Now they have provided certain exceptions also. So for the exceptions, we have a chart. We have understood the intent. Now, are the current employees of the company included? Yes or no?
Yes, please reply. Let's see how much you have understood the definition of private company. Let's see how many of you may have just give the answer.
Okay. So, some students have replied correctly that the employees who are in the employment of the company, that is the current employees, will not be included. Now, suppose there was an employee who was earlier in the employment of the company and at that time he was holding shares. So I am rude, you and that person is still holding shares in their name. So ex-employees, ex-employees are included. We are covering the proviso in this chart. Then one more person is there, joint holders. Joint holders will be included or not?
Yes, but it will be treated as single member.
Yes. So now if somebody give you a question and says, suppose the company has 210 members and they are saying it's a private company and they say that there were some of the members are employees, like 5 members are employees and 6 members are ex-employees. So will you count those members? No, you will say 210 minus 5 minus 6, that is 199 members. So it can be treated as a private company.
No, yes.
Exemption.
Yes, now there is an exemption to Section 8 companies. So it says that the requirement of having minimum paid up share capital shall not apply to Section 8 companies.
When such exemption shall be applicable,
तो clearly it says that
ये लाइन रट लो
क्योंकि ये आपको बहुत सेक्शंस में आपके साथ साथ मिलेगी
और आपको लिखने की भी जरूरत नहीं है.
आप बस ये ध्यान रखिएगा कि उन्होंने कोई डिफॉल्ट ना कमिट किया हो विद रिस्पेक्ट टू फाइलिंग ऑफ हिज फाइनेंशियल स्टेटमेंट अंडर सेक्शन 137 और इन द फाइलिंग ऑफ एनुअल रिटर्न अंडर सेक्शन 92 ऑफ द सेट एक्ट विद द रजिस्ट्रार. अगर उसने डिफॉल्ट कमिट नहीं किया है तो उसको जो भी एग्जेम्पशन प्राइवेट कंपनी को मिली है या किसी भी कंपनी को मिली है वो उसके ऊपर एग्जेम्पशन को एप्लीकेबल होगा और वो उस एग्जेम्पशन को बेनिफिट उठा सकता है विच कम अंडर द प्रिव्यू ऑफ दैट एग्जेम्पशन. लेकिन अगर उसने कोई डिफॉल्ट कर दिया विद रिस्पेक्ट टू द फाइलिंग ऑफ हिज फाइनेंशियल स्टेटमेंट और एनुअल रिटर्न तो वो उसको एग्जेम्पशन का लाभ नहीं मिलेगा. एंड इन दैट केस अगर जो भी उस मेन सेक्शन पे जो भी प्रोविजंस लगते हैं दैट ऑल प्रोविजंस विल आल्सो बी एप्लीकेबल ऑन सेड कंपनीज.
So you want an exemption also. For that you need to take some extra efforts. At least don't make a default. Like if you want exemption in law, at least you have to not default in your studies and you should be regular in your notes or annual return under 92. So a क्लिक करो और पढ़ लो।
बच्चे तो ये भी कई बार पूछते हैं डिफॉल्ट मतलब क्या? अरे
हाँ।
डिफॉल्ट मतलब आपने या तो ओमिशन आप या फिर नॉन कंप्लायंस, मतलब जो रिक्वायरमेंट थी एक्ट की that needs to be fulfilled and that has been omitted or it has been not complied in tune with the requirement of the section in order to meet up the requirements. अगर वो चीज होती है, omission होता है या नॉन कंप्लायंस होता है, तो it will be set to cause a default.
And then you will not be in a position to take the benefit of the exemption which is being provided to Section 8 companies. Section 8 companies are basically charitable institutions or the NGOs which one student has asked.
Then moving to the next is about the public company. तो ये समझ लो जिसने प्राइवेट कंपनी की डेफिनेशन ढंग से समझ ली तो उसके लिए पब्लिक कंपनी बाएं हाथ के खेल में, यानी कि उसको मेन समझना ही प्राइवेट कंपनी है। अगर उसको प्राइवेट कंपनी का कंसेप्ट क्लियर है then he can easily make out when a company is a public company. So it says that it means a company which is not a private company. ठीक है, which is not a private company. Or again the minimum paid up share capital as it is prescribed,
which the central government still hasn't prescribed. So for private companies also they have they prescribed? No. For public companies have they prescribed the minimum paid up share capital? No. हो गई डेफिनेशन पब्लिक कंपनी की। इट्स नॉट अ प्राइवेट कंपनी
एंड मिनिमम पेड
खत्म। प्रोविजो लर्न करेंगे हम थोड़ा सा।
अब प्रोविजो देखते हैं। प्रोविजो कहता है दैट अ कंपनी शैल बी सब्सिडरी ऑफ अ कंपनी नॉट बीइंग अ प्राइवेट कंपनी shall be deemed to be a public company for the purpose of this act even where such subsidiary company continues to be a private company in its articles. ये जरूर ध्यान से पढ़िए। ये समझाने से पहले मैं एक बार एग्जांपल पढ़ देती हूँ ताकि आप खुद समझ जाएंगे और थोड़ा बहुत मैं इसे आपको एक्सप्लेन भी कर दूंगी। यहाँ पे बताया एग्जांपल में एक कंपनी है विच इज अ प्राइवेट लिमिटेड और ये होली ओन सब्सिडरी है ऑफ अ कंपनी विच इज अ पब्लिक कंपनी। ठीक है, और इनकॉर्पोरेटेड भी हमारी कंपनीज एक्ट के अंदर है। So a private limited wanted to avail the exemption as given to private company, जो हमने आपको बताया है
this section, that is
exemption
268 what we have told you.
Yes.
So the company wants to avail the exemption as a private company.
अब क्या होता है कि A प्राइवेट लिमिटेड चूंकि सब्सिडरी है ए बी लिमिटेड का, तो उसे क्या समझा जाएगा? उसे पब्लिक कंपनी माना जाएगा क्योंकि ये हमारी बात प्रोविजो में दी गई है। क्योंकि ये कह रहा है कंपनी विच इज अ सब्सिडरी ऑफ अ कंपनी नॉट बीइंग अ प्राइवेट कंपनी मींस पब्लिक कंपनी, क्योंकि हमने पढ़ा है डेफिनेशन में विच इज नॉट अ प्राइवेट कंपनी। तो यहाँ पे वो क्लियर कर रहा है कि वो कंपनी जिसकी वो सब्सिडरी है वो प्राइवेट कंपनी नहीं है, दैट मीन्स इट इज अ पब्लिक कंपनी। तो यहाँ पे वो सब्सिडरी है पब्लिक कंपनी का, तो उस कंपनी को भी आप पब्लिक कंपनी मानेंगे फॉर द पर्पस ऑफ दिस एक्ट। और अगर सब्सिडरी और वैसी सब्सिडरी कंपनीज का नाम आर्टिकल में अगर प्राइवेट कंपनी भी मेंशन है तो भी इट मे कंटिन्यू बट इट शैल बी डीम्ड एज पब्लिक कंपनी।
यस, इट इज वेरी इंपॉर्टेंट। It can continue as a private company in the articles but deemed to be a public company. Deemed, what is the meaning of deemed? मानो या ना मानो, मानना ही पड़ेगा। And I give tribute to my teachers for this line. So I will, even if you does not want to take it, but since the act is saying that it will be treated as a public company, so it is being said that even if it's written in the articles, so in the articles it may continue as a private company, but it will be treated as a public
company. अब जब हमने एग्जाम्पल में हमने बताया क्योंकि जो ए प्राइवेट लिमिटेड थी वो सब्सिडरी थी पब्लिक कंपनी की, ए बी लिमिटेड की, देयरफॉर ए प्राइवेट लिमिटेड विल बी डीम्ड टू बी अ पब्लिक कंपनी इन लाइन विद द सेड प्रोविजन and will not be allowed to avail the exemptions as provided to the private company. आप इस एग्जाम्पल को समझ के फिर से एक बार इस प्रोविजन को पढ़िए ताकि आप कंसेप्ट को समझ पाए। और यकीन मानिए इस तरह के क्वेश्चंस एग्जाम्स में पूछे जाते हैं। दे टेस्ट योर अंडरस्टैंडिंग ऑफ द सब्जेक्ट। वो अंडरस्टैंडिंग करके आपको ये कंसेप्ट रिलेटेड टू प्राइवेट कंपनी या पब्लिक कंपनी का कितने अच्छे से समझ में आया। And that concept has been thoroughly checked through your working knowledge. Working knowledge मतलब कि आपको given situation में आप उसको कैसे apply कर रहे हैं कि whatever is given under the law. अब तो इस तरह से questions पूछे जाते हैं, and please read the provisions and then take the example in order to understand with more clarity.
Good number of students are replying to the queries that they are not being included. Very good. Okay, so good. Joint holders will be treated as single member. Deemed is equal to assumption. Yes, good. Deemed is equal to assumption. That you have to consider it as the way the act is saying. Okay, and apart from that, what is the okay? Why ex-employee is not a good question. Students, when the act says something, you have to consider it. So why of this, I will be replying to it. But before that, we will be going on a short break of 10 minutes. And it's 7:32, and we will be meeting you at 7:42. Let's see how many of you can actually understand this proviso with the help of the example. If you have actually understood this proviso due to this example, just say yes or no. We will be waiting for your answers after the break. Thank you. Yes. Welcome back, students. And we have got the answers from many of the students and all of them are correct. So now we will be taking another definition, that is of associate company. But before that, there is one thing that I would like to bring to your notice, that is we use the word deemed. And in the Act, nowhere the word deemed public company is used. That the word deemed has been used here to make you understand the provision in a better manner. But the Companies Act 2013 nowhere defines the word deemed public company. So don't use it from the examination point of view. It is from the understanding point of view. Apart from that, there is a student who has given us the definition as deemed is equal to assumption. Let's add just one more word to it. Deemed is equal to binding assumption.
Absolutely.
And for rest of the queries, we will be definitely taking them up. But since we are already at 7:44, so let's just start with the session and we will be taking up your queries later on. Don't worry about that. We have learned till now the types of companies: OPC, private company, and public company. Now the next company is associate company. Associate. That means there should be, what do we mean by associate? If we see it in general terms, associate means some relation between two people. Associate between a relationship between two people. So here we are not talking about people, we are talking about a company. So associate company will be in relation to another company. That is, if there is company A and company B, suppose there is company A and company B, so the relation, this company will be called as an associate company in relation to this company. We will be explaining this to you also, in which that other company has significant influence, which is not a subsidiary of the company having such influence, includes a joint venture. So, in this example, suppose there is a company with the name of A Limited. Now there is another company with the name of B Limited. First of all, two companies are there. They have to be considered in relation. They have to be considered in relation to one another. Now, if this company has a significant influence, let's use the word SI. That means A Limited has a significant influence on B Limited. What is the significant influence? We will read it. So, if A Limited has a significant influence on B Limited, which is not a subsidiary, this B Limited should not be a subsidiary of B Limited. It should not be a subsidiary of B Limited. And it includes a JV, that is a joint venture. So, let's see what is significant influence, and then we will come to this definition again. Significant influence means, यहाँ पे हमने पढ़ा subsidiary नहीं होना चाहिए. That means 50% तो नहीं होना चाहिए, 50% या उससे ज़्यादा. This is for sure. So this point is ruled out. So they have defined significant influence as control. When are we able to influence somebody? Either we love that person if we are in a in a social environment. If we love each other, we care for each other, then we can control. Or if we have, when can we have the influence? If we have some control over that person. So in this case, if the company has control over the other company, and how that control will be defined. either you control the voting powers because you have the decision making, or you control the participation in business decision. That means you again has the decision making power.
Even then they have right to appoint.
Yes, they have
the majority of the directors. Then again it can be said to be as a control.
Yes. So significant influence means a control of at least how much percent? They have said it as 20%. So through what all means? Through total voting powers or control of or participation in business decision. We can influence only through total. We have to have a control of 20% in what manner? Either voting power, which is related to decision making, or business decisions को control कर लिया, तो भी business decision making आपके control में है ही है. So significant influence की definition you can cover like this. And it says the expression joint venture means a joint agreement whereby the parties have joint control over the arrangement, have the rights to the net assets of the arrangement. If you are controlling the assets of the company, then you are having. Then it will be a joint venture. So now let's again come back to the definition of associate company. A Limited, let's call this as a parent company. This parent company has a significant influence of 20% because the word uses at least 20%. So 20% or more control over B Limited, and this B Limited is not a subsidiary of A Limited. Then this B Limited is an associate company of A Limited. That means in relation to A Limited, and it says, and it includes a joint venture. So here the main thing is 20% because it is holding a notable amount of shares of B Limited, but it is not holding that much amount of shares that this B Limited becomes a subsidiary of A Limited. Then the next type of company is holding and subsidiary, which we are discussing. Holding company, I'm just reading it for you. Holding company in relation to one or more company means a company of which such companies are subsidiary. That means somewhere we have to read the definition of subsidiary company for it. This is the main thing. Then only we will be able to understand what is a holding company. See, again they have given company includes any body corporate. If a company has one or more subsidiary, this we will explain after we have finished off the definition of subsidiary company. So, subsidiary company in relation to any other company. Again, be it associate company, be it subsidiary company, holding company, they will be dealt with respect to some other company. Some students were asking at the start of the session why we have jumbled up these sections. Yes, this is the reason. If you see the first three companies that we did with you, they were based on the number of members. And now the companies that we are doing, they are based on control and relation to other. So, in relation to the subsidiary company, in relation to other company is this. First of all, controls the composition of board of directors or excises or controls more than one half. The word here is more than. Just mark it in your books. More than. One half, what is the meaning of one half? It's 50%. So holding 50% shares will do? No. It says more than. So the company has to hold. The holding company has to hold. Rather, the word will be the holding company has to hold more than 50%. Then only it will be considered as a holding company, and this company will be treated as a subsidiary company. So this company, that company, let's say
one thing that this point needs to be taken care that where he talks about the control of this holding of total voting power. So you will see that it's also said it should be taken in aggregate, means if there are more than one subsidiary company. So aggregate means together we shall be looking after their holding of more than half of the total voting power.
Okay. So yes. So here it is A Limited, and if A Limited holds, suppose 51% shares of B Limited, then A Limited will be the holding company and B Limited will be the subsidiary company. This is with respect to this point. Now, controls the composition. Suppose there are 10 members, 10 directors. If A Limited holds the power or controls the composition, say for 8 and or whole 10 controls the composition of the board of directors, then in that case also, अगर ये BOD को कंट्रोल कर सकता है A Limited, तो भी B Limited A Limited की subsidiary होगी. Then provided that such class of classes of holding companies as may be prescribed, rules shall not have layers of subsidiaries beyond such numbers as may prescribed. Prescribed, and prescribed. What is this prescribed? 2 layers have been prescribed. Ma'am, what do we mean by layers? Suppose this is a company A Limited, B Limited, and there is one more company, C Limited. Now, this B Limited holds 51% shareholding in C Limited. Then C Limited is a subsidiary. Let me just use a different color pen. C Limited is a subsidiary and B Limited is a holding for the C Limited. But there is one more thing. This A Limited will be the holding company to B Limited as well as to C Limited. It cannot have more than 2 layers. अब इस C Limited में भी आगे कोई shares hold कर रखे हैं, the act is not talking about those companies. It has said कि we are recognizing till this on. Actually, this provision has a linkage at the final level, not only here. Now the Companies Act 2013 tries to restrict this waterfall model wherein subsidiary, a parent company, holding company, then subsidiaries and subsidiaries and subsidiaries and subsidiaries and subsidiaries. It has tried to reduce this waterfall model wherein you cannot make out that which is the ultimate holding company. So, wherever layers are used, generally in the entire Companies Act, only 2 layers are recognized. Explanation.
Actually, this provision was the result of the scams. A lot of scams has taken place. Where there were a lot of the subsidiaries, and there are a lot of the phishing of the funds here, there, and so it cannot make out who is the actual company and who has invested in which company. So to stop that particular type of scam, this section was introduced in the Companies Act 2013.
Okay. Then another thing is explanation for this clause. Now you will be easily able to understand with the diagram. It is the company shall be deemed to be a subsidiary company of the holding company even if the control as referred above is of another subsidiary. So we have covered it here. Even if the control is of another subsidiary. Okay. The composition of BOD shall be deemed to be controlled by another company if that other company by exercise of some power exercisable by it at its discretion can remove all or a majority of directors. See, I have in this example said, I think I have even rubbed it. I said, na, suppose they have 10 directors and out of this they can control either they can control the composition of all of these or 8 also. Majority, I'm just giving an example. So then in that case also it will be deemed to be a subsidiary company. Then the expression company includes any body corporate layers in relation to a holding company means its subsidiaries or subsidiaries. There is one more thing in this exception as per notification. If a company, suppose, let's explain this also with an example. If there is a company A Limited and it holds certain shares in B Limited, and suppose it is holding 51% shares. In normal scenario, B Limited will be a subsidiary company and A Limited will be a holding company. But suppose this A Limited is holding shares in B Limited in the fiduciary capacity. अब ये बला क्या है? What is this fiduciary? You have read it even at the foundation level. Fiduciary capacity in the Indian Contract Act. So fiduciary capacity means involving trust. Say it is holding, the A Limited is holding shares as a trustee, or we can say as an attorney.
Yes. So this can be actually there shall be a relationship of trust between them. Whether it may be a relation of husband and wife. This is also giving one of the informal
example.
Yes. So there is a trust, but anything which is done in a fiduciary capacity, because there is a relation of trust, in that case the other person is trusting on the other person who is you can say his partner. So in that case, it can be considered that in fiduciary, if anything is done, then they can be said it is not it cannot be considered, and in that case control it is not affecting actually over there.
Though they have the controlling power, but their intention is not to control.
And such agreement or contract cannot be executed. It cannot be said to be that there is any valid force or any validity.
Yes.
So, but here when we talk about the company that we are talking with respect to the holding of shares in another company. So this is with respect to the company, and there is a legal validity of this point. If anything is done under a fiduciary capacity, means in the relationship of a trust, then in that case, you can say that it cannot be the relationship of holding and subsidiary company cannot be considered over here. It shall not be counted for the purpose of determining this relationship. So this is the exception. So if suppose any question comes considered on this point, so you should know if any share is held in the capacity of fiduciary relationship, then there should not be considered this holding and subsidiary relationship.
Now, if we read this definition, you will be able to understand it controls the composition of the BOD and it exercises control of more than one half. So, moving on to the next definition, we have been talking about control. Like I told you that these these definitions are with respect to the controlling power. So what is the meaning of control? If you have read the above definitions, you can definitely say either they have the right to appoint the management of the company, or they control the management or the policy decision making, and they have the right to appoint majority of the directors. And this has to be done single-handedly? No. It can be done individually or in concern directly or indirectly, including by how you can have the control either by shareholding, or you have the management rights of the shareholders agreement or voting. So this sums up what is control and how companies are formed on the basis of control.
Now coming to the next important types of companies, that is the government companies. So you are seeing here that it clearly specifies that any company in which there shall be, in which the company is not having not less than 51% of the paid up share capital.
At least 51% should be.
Yes. Then it talks about that the holding shall be by the central government, that paid up share capital holding shall be by the central government or by any state government or governments, or partly by the central government or partly by one or all more state governments. So here the shareholding, if the government has a shareholding of more than for the more, 51% or more, in that case, you will be seeing that if the government is having such number of shareholding, either singly central government itself or either by any state government or governments, or partly by the central government and partly by one or more state governments, then such company shall be said to be a government company. So here the main important factor is the number of the holding of the paid up share capital. So you must remember the percentage specified here, holding, the specified holding of the paid up share capital. So as it is specified, not less than, that means 51% or more. Okay, that means not less than 51%. Then it talks about who can be the holders, that has been clearly specified. So this type of companies are said to be a government company. Further, the definition specifies that it includes a company which is a subsidiary company of such government company. I suppose that you understood by this line. It says that includes. Yani ki whatever is there, along with this, it says that a company which is a subsidiary. If any company is a subsidiary of government company, suppose this is a government company and this is a subsidiary company, then this company shall also be considered as a government company. Then further, more explanation is provided. In case some additional information is given when you talk about the paid up share capital. So in what context this terminology has to be interpreted? So it says that it shall be construed as total voting power, where shares with differential voting rights have been issued. Now, first see the example. Example states, first let's understand this terminology, total voting power. So what is the total voting power? Total voting power is with reference to any matter, which means the total number of votes cast in regard to the matter on a poll at a meeting of a company, if all the directors or their proxies having a right to vote on that matter are present at the meeting and cast their vote. When we talk about the total voting power, it is in relation to any matter. Okay? And there the total number of votes cast in regard to that matter is taken into consideration by polling at a meeting. And that too is saying they have the members who all are present at a meeting and cast their votes shall be taken into consideration for considering any matter. So this is known as total voting power. Now looking at the example, in order to understand the concept of government company, it says that X Industries Limited is a company with 25% shareholding of central government. 10% shareholding is held by a government of Maharashtra and 15% shareholding is held by central government and government of Rajasthan. As already said, it can be either held by the central government as given in the first case, or either it can be held by any state government in the second case, or it can be held by one or more state government along with central government. So this is given under the such situation. So here we have given the holding of the governments. Then it says that X Industries Limited is not a government company as there is no compliance of minimum holding of paid up share capital. 25%. Because if you add total, so how much it is resulting? 25% plus 10% plus 15. So it is reflecting 50%. Yes. And our section says about not less than 51%. So at least 51%, yani 51 or more. So if it is there, then that means it will be resulted in government company. But since yes, the non-compliance of the requirement of holding of paid up share capital, and that is why this company, X Industries Limited, cannot be considered as a government company. So you need to understand this concept, and many times the question is also asked on this particular concept. So just understand the requirements. What are the requirements in order to consider any company as a government company? If you are well conversant with the concept and the requirements, then you can easily apply that concept in the problem-based situations and then come up with the conclusions. Then moving to the next thing is that along with total voting power, there is one more concept of voting right. It means the right of a member of a company to vote in any meeting or by means of a postal ballot. this is total voting right is respect to any matter, and when voting right we talks about, it is respect to the right of the member. Okay, this is the two concepts, related concept. Please go through it. Then moving to the next is the small company. This is a very important concept, and this is most of the, you can say, important section which is generally being covered in the examination. From examination point of view, in one way or the other, the small company concept is being touched upon. So you need to understand this concept properly. The first is that this is that what does this reflects the nature of the small company, is that it is a private company.
Secondly, no public company will be a small company.
Yes, remember this point. Because there are certain requirements, and because of that requirement only, we have to consider when a company can be called as a small company. So it says that further, where the paid up share capital requirement, as the Act prescribed, that it does not exceed 50 lakh rupees or such higher amount as may be prescribed. If this is given, again you need to go with the rules. And there the rules prescribe the higher amount. Okay. And that has again put a limit that higher amount shall also be not more than 10 crore rupees.
Very confusing. Do the students have to remember the whole definition like this only?
No, I will come back to you how you can understand in a simplified manner and what as the main content you need to remember. But this is since it's a part of the Act. So first you need to understand what Act talks about. The Act prescribes the paid up capital limit as this, but the higher limit as will be prescribed, but it shall not be extending more than 10 crore rupees. Similarly, with respect to turnover, this says that the turnover for immediately preceding year does not exceed 2 crore rupees or such higher amount as may be prescribed. Again, it is imparting the higher limits on the turnover amount, that it shall not be more than 100 crore. That means the limit can be exceeded, but the limit of higher, that limit has been stopped, that it cannot be more than that. The government is saying that they can change any time this requirement of the limit of paid up share capital or turnover, but they have put the limit on the maximum amount also. So that may be prescribed by the rules. Okay, and further just check with the rules. This is very important. Rules specifies that the paid up share capital and turnover of the small company shall not exceed 2 crore rupees और रुपीज 20 करोड़ रिस्पेक्टिवली. यानी कि इन्होंने क्या किया, जब एक्ट प्रिस्क्राइब किया था उस टाइम पे उन्होंने लिमिट लगाई थी कि नॉट एक्सीडिंग 50 लाख रुपीज. ठीक है, जो उन्होंने ये लाइन पुटअप करके कि सच अमाउंट वाला की दे कैन रेज एनी टाइम दिस अमाउंट ऑफ 50 लाख बट इट शैल नॉट बी मोर देन 10 करोड़.
Like that means the rules cannot prescribe an amount
more than that the
10 crores.
Yes,
for paid up capital.
Similarly, for the turnover also, when that act was enacted, at that time they fixed the limit not exceeding 2 crore rupees. But along with that, they said कि भाई जब भी रूल इसको हम लिमिट को अमेंड करेंगे या इसको चेंज करेंगे या इसको इंक्रीज करेंगे तो इट शैल नॉट बी मोर देन 100 crore rupees. तो सिमिलरली जब इन्होंने रूल्स के माध्यम से ये चेंज किया तो जो 50 लाख की लिमिट थी पेड अप शेयर कैपिटल की वो हो गई आपकी 2 करोड़ और जो आपका 100 करोड़ का लिमिट जो आपका था इट इज गिवन
100 crores
2 crore रुपीज जो थी इट हैज बीन चेंज टू 20 crore रिस्पेक्टिवली. यानी कि आपकी जो हायर लिमिट है विद इन दैट लिमिट है ये दोनों लिमिट्स.
yes.
And now these two limits will prevail. जब आप क्वेश्चन कोई करेंगे of the related to small companies act, there you will check up with this requirement that paid up share capital shall not be more than 2 crores and turnover shall not be more than 20 crores respectively.
So the respective line will be this.
मतलब क्रक्स यही है, आपको पुरानी लिमिट देखने की जरूरत नहीं है. ठीक है, आपको ये जो आपका स्पेसिफिकेशन ऑफ डेफिनेशन डिटेल रूल्स के माध्यम से ये जो आपका इन्होंने एक्सीड करी है लिमिट, दैट लिमिट इज टू बी टेकन इनटू कंसीडरेशन एंड दे हैव मार्क्ड दैट इट शुड नॉट बी एक्सीडिंग. प्लीज नॉट एक्सीडिंग वर्ड इज देयर. अब आगे चाहे तो गवर्नमेंट इसको और एक्सीड कर देती है लेकिन अगेन देयर इज अ कैप ऑन द हायर
100 करोड़,
इसके बियॉन्ड नहीं जाएगी। अगर कभी करना होगा तो नीड टू चेंज इन द एक्ट, और एक्ट में चेंज करना अगेन इट्स अ बिग प्रोसेस। तो गवर्नमेंट ने क्या इंटेलिजेंटली काम किया, एज में प्रिस्क्राइब करके टू सर्टेन एक्सटेंट उन्होंने अपने पास अपनी ये पावर्स रखी, एज एंड व्हेन रिक्वायर्ड उनको लगता है तो उन्होंने इस हिसाब से यहाँ पे कंसिडरिंग इन टुडेस सिनेरियो दे हैव इंक्रीज द लिमिट, but yes, considering the maximum limit specified in the act.
So for you people, if we sum up, it can be simply said, other than a public company where the paid up share capital does not exceed 2 crores and the turnover does not exceed 20 crores.
ये आपको याद रखना है, क्रक्स यही है इस डेफिनेशन का। दूसरी चीज आपको ये जरूर याद रखना है, दिस इज वेरी इंपॉर्टेंट। कई बार आपको ये सब चीजें तो दे देते हैं, साथ में ये प्रोवाइडेड लगा देते हैं। प्रोवाइडेड में ये हो गया कि जो भी इस क्लॉज में दिया हुआ है वो उस पर अप्लाई नहीं होगा, बिकॉज नथिंग इन दिस क्लॉज। कौन सा क्लॉज? ऊपर वाला क्लॉज, ये दोनों, देन नथिंग इन दिस क्लॉज shall apply to होल्डिंग कंपनी और सब्सिडरी कंपनी। ठीक है, ये इसके पर्व्यू से बाहर है। ठीक है, अ कंपनी रजिस्टर अंडर सेक्शन 8 वो भी इसके प्रीव्यू से बाहर है। देन अ कंपनी और अ बॉडी कॉर्पोरेट गवर्न बाय एनी स्पेशल एक्ट।
स्पेशल एक्ट गवर्न कंपनीज आर ऑलवेज गिवन स्पेशल ट्रीटमेंट।
यस, तो वहां पर भी आपका ये जो सेक्शन है स्मॉल कंपनी के जो रिक्वायरमेंट्स है वो उस पर नहीं लगेगी। Let's try to understand this concept with the help of an example. Suppose यहाँ पे बता रखा है कि एक प्रॉफिट एंड लॉस अकाउंट है जिसमें इन्होंने बता रखा है जो भी एंडिंग इनका फाइनेंशियल ईयर का वो है, इसमें बता रखा है एंडिंग फाइनेंशियल ईयर में कि रेड प्राइवेट लिमिटेड है जिसका टर्नओवर उन्होंने स्पेसिफाई कर रखा है 1.5 करोड़। फिर उन्होंने पेड अप शेयर कैपिटल 40 लाख बता रखी है। अब ये वो पूछना चाहते हैं इसमें क्या आप लोग बताएंगे हमें, क्या यहाँ पर प्राइवेट जो एस प्राइवेट लिमिटेड है, रेड प्राइवेट, हाँ सॉरी, यहाँ पे जो रेड प्राइवेट लिमिटेड है क्या वो स्मॉल कंपनी मानी जाएगी? यस स्टूडेंट्स, तो हियर आंसर इज ऑलरेडी देयर, बट आई एम जस्ट आस्किंग यू इन व्हाट मैनर यू विल say whether this company will be considered as a small company or not, मतलब on what basis you will justify your answer, तो प्लीज आप बताइएगा। Though I'm explaining because looking at the time constraints we need to little bit move fast, तो यहाँ पे हम बता देते हैं आपको आंसर। जो रेड प्राइवेट लिमिटेड है उसका जो टर्नओवर एंड पेड अप कैपिटल नॉर्म्स है वो हमारी रिक्वायरमेंट को फुलफिल करता है, क्योंकि हमने वहां पे नॉट एक्सीडिंग वर्ड यूज किया है, और ये दोनों ही लिमिट चाहे आप पेड अप शेयर कैपिटल का ले या फिर टर्नओवर का ले, दोनों ही विद इन द लिमिट्स हैं, दैट इज ऑफ 2 करोड़ एंड 20 करोड़, दोनों ही विद इन दैट लिमिट है, इसलिए ये कंप्लाई करता है with meet up the requirements of the small company, and that is why it will be considered as a small company.
Yes, you have given correct answers, Matanjali, Himanshu Gupta. Yes,
but Matanjali is saying it's not a small company.
It's not a small company. Why?
Matanjali, already I told you have to check with the requirements of the company.
This is a very important thing actually. Matanjali, if you are seeing this question, and if you are doing it with respect to some other question which is there in the study material, it has been changed. That's why you are confused.
और ऐसा होता है एग्जाम में भी, जब फैक्ट्स को थोड़ा ट्विस्ट कर देते हैं और हम ये सोचते हैं कि we have already gone to this particular example from the study material without considering the facts or going into understanding of what they have been asked. So हम कई बार आंसर दे देते हैं और वो आंसर फिर हमारा गलत हो जाता है। तो देयर इज ऑलवेज अ गुड दैट यू रीड द क्वेश्चन प्रॉपरली, आप अच्छे से पढ़िए एंड देन फाइंड आउट व्हाट दे आर आस्किंग फॉर। तो यहाँ पे जो हमने रिक्वायरमेंट्स दी है, लिटिल बिट वी हैव ट्विस्टेड द फैक्ट्स इन ऑर्डर जस्ट टू मेक यू नो कि ऐसे क्वेश्चन पे छोटे ट्विस्ट करके भी वो क्वेश्चन पूछ लेते हैं एंड दे चेक योर अंडरस्टैंडिंग द कॉन्सेप्ट।
मैम, इट्स टर्नओवर इज मोर देन 20 crores, no, it's 1.5 crores. Then there is one student, I will not take the name, that has given as per section 285, Red Private Limited can be deemed a small company. Just a small correction. It is a small company. Don't write the word deemed a small company.
क्योंकि एक्ट में हर एक चीज का सेंस
एक वर्ड होता है, यस,
मीनिंग होता है, एक मीनिंग आप कंस्ट्रक्ट कर सकते हैं। तो अनलेस एंड अंटिल एक्ट वोंट यूज दैट वर्ड So kindly avoid it using word.
And like in the last session also we said that when you are reading the detailed material again and again, you will tend to know the exact words. This is it. Dear student, we are not telling you from the point of view that you have to take out your mistakes. It's more from the point of view of fraud correcting, because in the examination you may write deemed. However, the correct word is not deemed. It is a small.
Yes.
When it is with relation to a public and private company, whether this private company will be deemed to be a public company, there you can use the word that this private company will be deemed to be a public company. There you may use, not here.
अच्छा ये
It's okay with
that
baby,
is fine.
not a problem.
Even Jain is saying it is not a small company because it's a holding company, but where it is given in the question, it's a holding company. That is what we are emphasizing. Read the questions properly.
Yes, because you are referring the study material. I am impressed and I am happy that you are reading the study material. But suppose the same question comes in exam. Just giving you an example. What will happen since you are so in tune with whatever is written in the study material? The moment you see those lines and everything, you will not apply your mind. Nakal ke liye bhi we have to put it through in a better manner. So आप थोड़ा सा ध्यान दीजिए, because this has happened many a times. Even a small twist in the facts will lead to a altogether different answer. But it's good that you are referring the this study material and reading it from there. So most of the students have given the correct answer, and thank you for making that mistake, dear students, because it is because of you students. The other students are having an example that we might have missed this point in our previous session also, but because of you, we appreciate that we are able to tell one more point of mistake which students commit in examination. Thank you.
Now moving to the next definition.
So we have now been doing only about the types of companies. So most of the types of companies as covered in the definitions we have taken up. Let's understand another important concept, which is types of share capital. Share capital, as we know, why share capital? The company gets capital. Suppose it has decided it wants this much of capital, and the company cannot have all the capital from its own pocket. So the amount X will be distributed or cut or divided into small portions, and the public will be told that Shark Tank types, that Shark Tank may, the way you see that I have an idea to produce these bottles and I want you to invest in my company, and I need X amount to produce these bottles, but I cannot do it myself, so I am inviting you people to invest in my company. Suppose I need 20 crores for this, just a vague example. So hypothetical example rather I should say. So I am saying that I need 20 crores. One student cannot give me whole 20 crores. So a large number of students will come or people will come and invest in my company. Suppose I have divided that X amount into 10 lakh units. Some students will come. These units are known as shares. So when the capital is divided into small pieces, it is known as shares. Share means a share, and now you have a share, मतलब आपका हिस्सा है in the share capital of the company, and it includes stock. This is a definition. Simple. Now, you must be well conversant with this concept. You have read it in 10th, no, not 10th, 12th, and your foundation level. And you must be reading it simultaneously in your accounting class also. Right? This is covered in law subject also. Authorized capital, subscribed capital, issued capital, called up capital, and paid up capital. I think I need X amount of capital. Okay. Or rather, I need 20 crore rupees for investing in my company. I have called you people. So I think I need 20 crores. This is the authorized capital which I will write in the memorandum. I need this much of capital. So capital as is authorized by the memorandum of a company to be the maximum amount of share capital. Now, I have floated the idea. Some people like it and some people don't. So, such part of the capital which is for the time being subscribed by the members. Sometimes we have oversubscription also, but suppose it is not subscribed by everyone. And I get subscription for only 10 crores. Okay. So that will be the subscribed capital. But when I start working on it, I think I don't need 10 crores. I need just 7 crores. So then that issued capital, then I will issue shares only to the tune of 7 crores. So that will be the issued capital. Or if I need all those 7 crores, then the whole subscribed capital will be the issued capital. Now what happens is, I have asked those 7 crores rupees from people, and I say, okay, I think I'm needing 7 crores, but instead of calling the whole amount right now, let me just, if my share is 10 per, it's 10 per share, then I think I don't need the whole amount of 7 crores right now. Let's call it 8 per share. So that 8 will be the called up capital. Now, what happens? I have called 8, but there are few shareholders, suppose 5 shareholders, who don't even pay that 8. And the amount that I will receive then will be my paid up. Paid up capital is the actual amount credited as paid up. And it is the equivalent to the amount received as paid up capital in respect of the shares that were issued. So let's analyze this definition with the help of an example. ABC Limited was registered with the registrar with an authorized capital. So the biggest is authorized, then subscribed, then issued. Then we have issued, then we have the called up capital, and then the paid up capital. They may be equal, but if there is called up, then paid up and issued will definite. If there are calls and areas, then in that case, the paid up capital and issued capital will not be same. In response to the advertisements made by the company to buy shares in the company, applications have been received for 10 lakh shares. But company actually issued 7 lakh shares, where company has called for 8 per share. I think this is pretty clear. All the shareholders have paid the called up amount except 3 shareholders who still owe for their 6,000 shares. Just notice. Earlier they were talking about amounts and all those things. Here suddenly, in the first line, they are talking about rupees. Then in the second, they have talked about shares. Then again, they are talking about in terms of shares. So just keep in mind that you have to think that whether they are talking in terms of shares or in terms of rupees. So amount of various capitals with which it was registered was authorized. So rupees 2 crore is your authorized capital. Then subscribed, because it said that company received for 10 lakh shares. Multiplied by 10, it will be 1 crore. Then issued capital, because it thought that I don't need that much, it issued only 7 lakh shares. So issued capital would be 7 lakh shares into 10, that is 70 lakh. Now it has called for only 8 per share. So called up capital would be 7 lakh shares into rupees 8, that is rupees 56 lakh. Now 6,000 shares are still unpaid for, which are being held by 3 shareholders. See, they have said 3 shareholders holding 6,000 shares. So you don't have to take 3. You have to take the number of shares. So paid up capital would be 56 lakh minus the number of shares which are still not being paid for. So 56 lakh minus 48,000. It's 55,52,000, which is the paid up cap. I hope you all are understanding the things by now. Wait, Jayendra Kumar, we are just taking up few of the queries. Jayendra Kumar is saying, wait ma'am, once talk about the small company, once please check study material. It's saying both fact, it is not a small company. Dear Jayendra, please read the facts of, and just a moment, let me just open
again
the example. Yes. The example in the study material, can I have the study material? It was saying one more thing. Here, just see, we have changed the facts of the question. We are just talking about one company, which is this Red Limited. We are not talking about two companies. And in the study material, if you see, there are two companies. One is H Limited and one is S Limited. So there lies the difference. We are now talking only in terms of this Red Limited, whether this Red Limited is a small company or not. See, we have also made a mistake. We did not change it as S Limited to Red Limited, but we have changed the whole question for you. There is no relation of holding and subsidiary in this question.
Nowhere this term is there, holding or subsidiary,
which is there in the study material. So I think now this will clear all your doubts with respect to this question. So that answers approximately the queries of, just a moment. (17 to 18 students are having this query. So I will not be taking this query further. I think it's now completely clear. So good, you have replied to without even asking. We are happy that you are solving the questions with us. Even if we are not asking, you are solving this. It will help you in the examination. And once we are done with the session and you will be doing it again on your own, you will feel tremendous change in the way you are reading it. So talking about holding, I don't even want to see that how many students have now. This is the query that students are facing. Okay, one more thing. That small company thing is there. So they have one more problem. 40 crores and this 40 lakhs. See, they are saying 2 crores. So if it's less than that, any amount is there, they are not bothered about that. Okay, what is that amount?
Only the thing is to be considered the limit there, that should not be exceeding from that time. The limit should be kept in mind. So while seeing this is cares to be taken that the prescribed limit is not exceeded, though it may be of any of the amount for the fulfillment of the requirement of the small company.
Neha, you don't have to remember the old limit. Actually, the act was framed in such a sense that if just a moment, we will be switching to many things simultaneously. I hope so. You are not getting perturbed like how we are explaining. So small company wala thing people are asking. It's something like 50 lakh. If the central government has the power to change a certain amount X, which shall not be more than I think 10 crores. So they say 50 lakh से कम होना चाहिए या कोई ऐसा अमाउंट जो हम प्रिस्क्राइब करें, लेकिन ये जो एक्स अमाउंट है ना, ये 10 करोड़ से ज्यादा नहीं होना चाहिए. तो उस सेंट्रल गवर्नमेंट ने सारी चीजें बोल, ये एक्स अमाउंट 10 करोड़ से ज्यादा नहीं होगा. This X amount cannot be more than 10 crores. So for the English speaking audience, the central government says that 50 lakh amount is there. I'm talking with respect to paid up capital. Earlier they said 50 lakh, say it should be less than 50 lakh, but we can prescribe an amount which shall not be more than which shall not be more than 10 crores. And now they are giving this X amount time and again. Right now, this amount of X is 2 crore. You need to remember only this. This all is from the explanation point of view. See,
and since it's still the part of the act,
yes,
this is why we have given over here in order to make you understand what the act prescribes. But yes, as per the amendment, since the amendment here rules, as per the rules, they have amended this limit. So this latest limit is to be kept in mind. So accordingly, 2 crore and 20 crore is to be taken into consideration while looking after whether such company is a small company or not.
and our aim is to make you how to read. We are simultaneously giving you small things also, like in the form of a chart or a diagram, so that you retain it. So we are teaching you how to read the act as well as how to retain that. So we have covered everything. With respect to, some people might say that we have written the exact language of law. We are showing you how to read, and through our charts, we are trying to help you how to retain the text. So we are already at 8:34. Whether we should proceed with further things?
I suppose, Shraddha, because I mean, many more things are to be covered and many important concepts are still left over. So we are just thinking, let's plan for another session in order to cover up the other required definitions which are relevant and important for the students in order to understanding of how does the working, who all takes care of the companies, how the management goes, and how does the working of the company take place. So with respect to that, we will just come up with our updated schedule with respect to regarding the continuing of this session, and whereby we shall be covering the other rest of the definitions and looking at the query part. Let's see if there's any other specific queries.
Even after I think I have explained. Okay, thank you, Neha, for telling me that now it's clear. Like, please, I think we will be uploading these notes. Just since you will be attending it on either your phone or what do we call it, iPad or laptop, just take a screenshot of this example. I hope you have taken it by now. Though we will be uploading the notes, then also I'm saying, and now read the example of the study material, because students, just if you are able to hear me, just hold on for a second. Any of the students, please reply to us. Are you able to hear us and see us? Let's see. Technical team, please guide us whether the students are able to hear us. Technical team, please let us know whether the students are able to hear us.
Stop sharing. Please pause the camera.
Stop sharing. Stop sharing.
Dear students, sorry for the glitch. I think now you will be able to hear us. Okay, sorry. There was some glitch. I don't know what happened. So just read that example, and then in the next session, we will be taking one more session on this, and we will let you know about that when the session will be held and through the schedule that you have. Since we cannot take everything right now, and we will be replying to all your queries, need not worry about that. So now I think students are even able to hear us. If any queries left as of now,
we will take it in coming sessions.
yes,
Don't
and
worry
because
about
many
that.
of the definitions are still left and we are already at 8:38, we will see you again and inform you about the rest of the preliminary chapter when it will be held. You can check it through the schedule. The schedule will be updated and you can see it from there. So it's bye for now. Thanks
Yes.
for your patient listening and working with us. It has been really great to have you as our audience.
Absolutely. And even it's a pleasure for us to connect with you in this manner and through this platform. And with this, we would like to close our session. And don't worry about the notes. Definitely, they will be made available for you. And that too, in a more lucid manner, in order to make you easily understand the concept in some other form that it is easy to retain also. So we will try our best to make you available the notes as soon as possible, and we will be taking up our next session in continuation.
In continuation on this, however, on 14th of May, your chapter 2, that is incorporation of companies and matters incidental thereto, will be getting started on 14th of May. So see that also. However, the continuation of this session will be held in some time and we will be taking up that also and it will be informed to you. So it's thank you.
Yes.
And take care. Have a good night's sleep. Study hard and have fun. Stay cool.
Stay calm, happy, and surround with the happy people, the genuine people, because this will create a positive environment, and that is very important. So to be rest, your mind be in peace. So with that, you enjoy
your rest of the day.
So meal time, enjoy your meal, and with this, we would like to
end the session. Thank you.
Yes.